All right. Let me know when you're ready to test. Yeah. Right, that's. And then you can check. I turn the volume up too.
Okay, beautiful. Welcome, everybody. Welcome to this historic hearing of the Yoorrook Justice Commission. We're going to start with a traditional owner, Andrew Gardner, speaking to us before we commence our business. Can't see Andrew. Andrew, where are you? Please.
Chapsticks here with Wurundjeri Woiwurrung on them, so I won't be throwing them or making too much noise. Can you hear me? All right, good. Andrew Gardner, I'm the Deputy Chair at the Wurundjeri Woiwurrung Cultural Heritage Aboriginal Corporation, and also an elder of the Wurundjeri people. Also represent the Wurundjeri Woiwurrung on the First Peoples Assembly Victoria. I'd like to add some comments that were probably provided up at Hillsville, at the Hillsville Sanctuary at the Coronado Bushland, but also earlier by Auntie Joy. I want to acknowledge all the Aboriginal and Torres Strait Islander people in the room, particularly our elders that are here and other elders that are here from around the state. Acknowledge them and pay respects to the elders past, present and emerging. What I wanted to comment on was that our traditions are born out of our cultural respect for elders, for our cultural authority, our cultural knowledge holders and our wisdom givers. We believe in what our elders and ancestors tell us as being the truth, as we have an oral history and have an oral history, not a written one. Our history and customs have been passed down for thousands of years through stories around campfires. My ancestry is through my mother, Gloria Terrick Gardner, my grandmother, Jessie Jemima Wandon Terrick, my great-great-grandfather, Robert Wandon, my great-great-grandmother, Annie Borat, sister of Barrack, Uncle William Barrack, my great-great-great-grandfather, Babajan, headman of the Wurundjeri Willem clan of the Woiwurrung people back in the 1830s. He was around in the time when Batman tried to introduce his treaty then. We can say, as we are right people for country, our traditional country is from the mouth of the Werribee River in the west, north along the river to its headwaters in the Great Dividing Range, then easterly across the range to Mount Baw Baw, then south through Bunyip and then westerly across to Mordialloc Creek. A summary. Since the mid-1800s, we had our traditional land sold from under us without our consent. We never ceded our sovereign rights. We have been dispossessed, pushed onto missions that were like concentration camps, having to get permission to do almost anything from the mission manager and the Aborigines Protection Board. When the missions closed early 1900s, our people were expected to assimilate into the rest of society, but we were rejected with racism and discrimination. Then, under further government policy, our children were forcibly removed to break down our families and communities. However, we have survived these controlling and genocidal policies of the past. Some details. In 1835, John Batman came to this area, sought a treaty with our ancestors near the Merry Creek. This was spoken about a little bit earlier with Auntie Joy. This document was written in longhand in English prose with common law accents. It did not have Aboriginal cultural law expressed in it. That document basically gave us all the rights of ownership. That document basically gave him all the rights of ownership and could be seen today as being the first property developer. Our ancestors understood from limited translation that Batman sought short-term occupancy, and they agreed to a tanderum, a temporary use of the land, a bit like a temporary visitor's visa. But unfortunately, that became a permanent residency. That treaty was later made void by the Governor of Van Diemen's Land. Copy still exists in the Melbourne Museum. 4 years later, 1839, vast tracts of our traditional country were sold from under us, between the Plenty River and the Werribee River. We had not ceded our sovereign rights to our country, nor did we sell it or give it away. So how did a government, which was not in this place, have the authority to sell our land? In only 2 years, he was sold to just 29 British men. Our people were never compensated for the loss of this land. After being scared off our lands by gunfire that they'd never heard before, our ancestors became malnourished and sick as they could not hunt and gather their traditional foods. 1860s, 1862 particularly, the first of many missions were established around the state. Our people were herded on to missions to be totally controlled. Our people had to ask permission from the Aborigines Protection Board whether they could marry, where they could build a hut, what skills they could learn, whether they could leave the mission to find work, or even travel to visit sick relatives. But they had to dress like Europeans and attend church on Sundays to listen to Christian sermons. In the late 1890s, the Aborigines Half-Caste Act was passed in state parliament. Just prior to that, the parliament didn't exist until 1851, yeah? Parliament House wasn't built until 1856. So anybody who had white parentage had to leave the mission under that act. 1924, the Corandurk mission was closed, and by the 1930s, all missions had been closed around the state. Aboriginal people were expected to integrate into general society. Only thing, racism took over. They were rejected, forced to live on the outskirts of town, became known as fringe dwellers. This year marks 100 years since the mission at Corandurk was closed, and actually 200 years since the birth of Uncle William Burrick. Both these things being celebrated this year by our mob. You've heard or are aware of many treks Uncle Burrick made from Corandurk to Parliament House. Best part of a day and a half's walk, and 2 days of it rained along the way. To hand-deliver petitions that were received, and they were told to return home. These petitions were never really properly acted on. Government policy required our children to be forcibly removed and stolen from their families, supposedly for a better life. But far too often, they were sent to orphanages to be trained as domestic servants for the girls or farmhands for the boys. Both were preyed upon and abused by ruthless white overseers. These children became known as stolen generations. This was designed to break down our families. We have survived all forms of genocide attributed to us as a people by invaders who purposely dispossessed us and unlawfully, LAW, and unlawfully, LORE, treated us as inferior. For example, as was noted earlier by Auntie Joy, our returned servicemen from the First and Second World Wars did not receive the favours of a grateful country like their white counterparts did, with gifts of soldier settlement blocks to restart their lives. Our people were decamped and told to return to the mission. They had to find their way home. They had to find their own way home. Accepting the past can give us understanding and direction for a new and better future of freedom and equality. Everybody has the right to a free and fair life. It is the support that we require for our self-determination that will give us and get us there through treaty. We've been a part of this landscape for more than 65,000 years, and as the longest living continuous culture in the world, Victorians should recognise and appreciate this fact. We are the first peoples of this country. So from the tips of the leaves of the trees, the roots in the ground, we share our country with you today. So Womanjika Yemen Kundi Bik, Wurundjeri Wurrung Balak. Welcome to the traditional country of the Wurundjeri clans of the Wurrung people. Ngojin, thank you.
Thank you, Andrew. Thank you. Could I welcome you all to today's hearing of the Yoorrook Justice Commission. It is truly historic in that it's the first truth-telling process of its kind in Australia. I also want to put on the record a thank you to Auntie Joy Wandon Murphy for the welcome to country and to her son Craig for the smoking ceremony. Commissioners are very grateful for your presence here today. I would like also to acknowledge the Wurundjeri people, who are the traditional owners of the lands upon which we are sitting today. Shall I go to council for the record? I'll throw to you, Tony, for the opening of the official.
Thank you, Commissioners. I appear as co-senior counsel assisting this commission today, joined by junior counsel Sarala Fitzgerald and Tim Goodwin. On behalf of counsel assisting and solicitors assisting, we acknowledge the Wurundjeri people and all First Peoples of Victoria in this hearing. Commissioners, the first witness today and only witness is the Premier of Victoria. We might, before going to the witness, hear from counsel assisting for the state.
Please, the Commissioners, I appear with Ms Keating and Dr Hilly on behalf of the State of Victoria. And in so appearing, I'd like to acknowledge the traditional owners of the lands on which we meet, the people of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders, past and present, and I extend that respect to all First Nations people here today and express our gratitude for our inclusion in the ceremony this morning. Please, the Commission.
In continuing, I have a little bit more to say before we continue on, but did you want to swear the people?
May it please the Commission. Are we hearing from Commissioner Lovett at this point?
Me first. I wish to pay my respects to all elders past and present and acknowledge all Victorian traditional owners. And I take this opportunity to again acknowledge on the record Commissioner Hunter, Commissioner Lovett, Commissioner Walter and Commissioner North. As I said, today is an historic moment in the 236 years of colonial rule in Australia. Today, hearing evidence from the Premier, Victoria, Jacinta Allan, is an historic moment that I hope everybody who's been present today will remember and talk about in the future to their children and grandchildren. This is the first time a head of state has appeared before an Indigenous-led truth-telling commission. Last week, Premier Allan visited Wurundjeri land that was part of the former Corranderk Aboriginal Mission near Hillsville. The story of Corranderk, in many ways, is the story of injustice against First Peoples in Victoria and of the strength and the resistance our people continue to show in response. From 1835 onwards, the Wurundjeri had their lands and waters taken by the European colonisers. Led by Simon Wonga and Barak, they successfully advocated for a reserve where they could raise their families. For many years, the reserve prospered. Greed, racism and mismanagement caused the so-called permanent resident to be broken up. The mission was shut down 100 years ago, as Andrew has said. Then in 1948, the remaining land was given to the Returned Soldier Settlement Scheme. None of that land went to Aboriginal returned soldiers. Today, less than 10% of the original Corranderk Reserve has been returned to Aboriginal ownership. In 1968, W.E.H. Stanner talked about the Great Australian Silence. He argued that Australian history was infected by a cult of forgetfulness practiced on a national scale. Sadly, history is written by those with power, the invaders, almost always ignoring the voices of First Peoples. This leads to a distorted view of the past and does a disservice to us all. We all suffer and are the poorer when the true history of this place is not known. For decades, First Peoples of Victoria and our allies have fought to correct the historical record in this country. Yoorrook would not have been possible without their strength and resistance. Truth-telling is about including our voices about the history of these lands on the public record. By knowing and understanding the truth, the great silence can be ended. We can build a shared understanding about the injustice that has occurred. All Victorians can work together to right the wrongs of the past and build a better and richer future for all Victorians. Premier, I thank you for appearing before Yoorrook today. Your words will live on the public record for generations to come. When you leave here today, I ask you to live up to your words and with your actions. First Peoples have faced a long history of being let down by successive governments and their leaders. Broken promises, unfulfilled commitments and apologies followed by inertia. Unless accompanied by genuine and lasting change, acknowledgements and apologies mean little. Worse, they give the impression that action is coming whilst maintaining the status quo. And I remind you that the status quo for our people is a child protection system in which governments remove our children from their families and communities at horrific rates, nearly 2 decades after the apology to the stolen generations. The status quo is the mass imprisonment of our people more than 3 decades after the Royal Commission into Aboriginal deaths in custody. Racism and inequality affect First Peoples in almost every aspect of our lives, from schooling and work to getting housing and to accessing healthcare. There is an unbroken line of injustice which runs from the original theft of our lands and waters until today. The truth is, we cannot secure justice for First Peoples without transforming the laws and policies which by design continue to disadvantage us. The evidence Yoorrook has heard is clear. First Peoples need the power, the resources and the authority to make decisions about the issues that affect our lives. The great silence that Stenna spoke about must end. During Yoorrook's term, that silence has come to be filled by the voices of Victorian First Peoples. And I thank all of those who have come to speak with us, First Nations and other Victorians. Those of you who follow us and visit us for the hearings, I thank you all for being here. Now is the time to build a better shared future for all Victorians. Now is the time for change for our people, for action and justice. Premier, as we move forward, we must move beyond words. The power imbalance must end. Implementation of the recommendations articulated by First Peoples and indeed by the Commission are urgent. We do not want to be talking about failure of this Commission in 30 years' time. Premier, your evidence must become and lead to real change for our people. Thank you for coming today.
Thank you, Chair. Premier, our people have been waiting over 200 years for this day to come. For the past 8 months, the Yoorrook Justice Commission has extensively travelled this state, investigating the injustice experienced by First Peoples in relation to our lands and waters since colonisation. We gathered a compelling body of evidence about colonisation processes and their impacts for Victorian First Peoples, and about current laws and policies failing to properly address these injustices. We started gathering evidence through public submissions under notices to produce and from over 850 traditional owners across a series of roundtables. Guided by this background material and First Peoples' direct voices, we commenced our formal hearings in Portland on Gunditjmara. Portland was the first permanent occupation by European colonisers of First Peoples' lands in this state. It was the start of an illegal land grab on a massive scale led by squatters and pastoralists that spread across Victoria. Historians told Yoorrook that the theft of First Peoples' land in Victoria was the swiftest and most rapid expansion of any colony in European history. We heard distressing evidence about the slaughter, massacres committed by colonisers that occupied the land grab, and the failure of colonial governments to properly protect First Peoples. It was openly assumed in the initial stages of the colony that First Peoples would simply die out. Within 20 years of the first permanent settlement, the population of First Peoples in Victoria had plummeted by around 80% to just under 2,000 people. Our lands, our waters, our lives were taken with shocking speed and brutality. Many Victorian First Peoples were forced to live on missions and reserves and forbidden Premier from using language and practicing their culture and ceremony. More than one witness has observed that the missions and reserve system marked the beginning of the Aboriginal deaths in custody. Yet, despite all of the injustices for Victorian First Peoples, we have heard many of them signed up to fight in World War I, World War II, and the Vietnam War, wars which were not ours, only return home to racist laws and policies that excluded them from soldier settlements except for 2 cases. Even worse, some saw of the supposedly permanent Aboriginal reserves for the protection of First Peoples were closed and carved up to be granted as farming land to white soldiers. This, Premier, is a double dispossession. These injustices have never been recognised or addressed. Due to the strength and resistance of First Peoples, there have been steps forward under native title and the Traditional Owner Settlement Agreement. However, traditional owners have told Yoorrook that despite their hard-fought gains in land rights, they are simply fighting over the crumbs left on the table after the state has protected the rights of other interest holders and that of the state, and the state's had its own full share. And even then, as a number of witnesses have told us, these laws and policies have forced and are forcing First Peoples to fight each other for the crumbs. Last week, we heard from your ministers, Premier, about the extraordinary sums of wealth generated from the lands and waters taken from First Peoples. $1.89 billion in revenue from forestry and grazing licenses in a 13-year period. $83 billion in the revenues to the state from water in the same time period. $287 billion of gold extracted from our land since 1851. Minister Shing, Minister D'Ambrosio, Minister Demopoulos were all asked how much of this wealth is shared with traditional owners directly. They all gave the same answer: none. Yoorrook has been repeatedly told that the current land rights mechanism in Victoria are not fit for purpose. Traditional owners and state witnesses both agree that things must change, and change must start with self-determination. Yoorrook has heard that when power, resources and authority are transferred to First Peoples, our communities thrive and prosper. When First Peoples can care for country, everyone benefits. Premier, we are here today in the hope of a better understanding your government's commitment to change and reform, to right the wrongs and injustices of the past and those injustices that continue to this day. Self-determination, true self-determination, including through treaties, is already happening for Indigenous peoples across the world, including in other former British colonies. Australia and Victoria, our state, is lagging behind. Premier, your government, through establishing this Truth Commission and with its commitment to treaty, has chosen a path towards highlighting and addressing these injustices. Commissioners wish to acknowledge the participation of a number of your ministers in Yoorrook processes and the frank and sometimes heartfelt acknowledgement and apologies of wrongs and opportunities for a better shared future. But it's your government's actions and the success of those actions that First Peoples are relying upon, rather than your words, Premier. The evidence Yoorrook has gathered shows there is a way ahead for a better shared future for all Victorians. When the state and First Peoples come together as equals, we will all prosper. You are the first sitting Premier to come before a truth-telling commission in Australian history, and you have the ability to lead our state to negotiate the first ever treaty in the nation's history. I don't want my children and your children, who I understand of a similar age, having to fight the same fight that our ancestors, elders, and community have had to fight. Let's not leave it to future generations to make right on the wrongs, so all our children can grow up sharing a prosperous future that we can all be proud of, Premier. Thank you.
Thank you, Commissioner Lovett. Council, may we continue?
Thank you, Chair. I call the Honourable Jacinta Allan MP, Premier of Victoria. Of course, Commissioners, the Premier is here and available and ready to proceed. Premier, could I ask you to tell the Commissioners your full name?
Jacinta Marie Allan.
And Premier, the evidence that you are about to give, do you undertake to provide truthful evidence to the Yoorrook Justice Commission?
Most certainly do.
Commissioners, I understand that the Premier has an opening statement which she would like to deliver. I will, before she commences, indicate that it's planned to proceed through to lunch at approximately 1:30, but if the Premier at any point needs a break, or the Commissioners, of course, we can accommodate that.
Thank you.
Would you like to proceed with your opening statement?
Thank you. I want to begin by acknowledging the traditional owners of the lands on which we're on today, the Wurundjeri peoples of the Kulin Nation, and pay my respects to their elders past and present. I'd like to extend that acknowledgement to the traditional owners of the land on where I live and where I'm also lucky to represent. I'm proud to call Bendigo home, and I'm prouder still to know that the Dja Dja Wurrung people have called it home for tens of thousands of years. I extend that same respect to all traditional owners and First Peoples across Victoria, including the First Peoples who are watching the Commission's proceedings today. I acknowledge that sovereignty was never ceded, and that traditional owners' spiritual and ancestral ties to their lands and waters can never be extinguished. Thank you, Commissioners, for the opportunity to appear before you today as part of this important truth-telling process. It is truly an honour to be the first head of government in Australia to participate in a process of this kind. I'd also like to thank you for your work to date and the valuable difference you are making in creating a better future for our state. For thousands of generations, First Peoples have maintained their connection to culture and country which is now referred to as Victoria. When the British first arrived, more than 35 languages were spoken. Between 300 to 500 clan groups lived and flourished here, tethered to this place by tens of thousands of years of history and the longest continuous living cultures in the world. Evidence of First Peoples' continuous connection can be found across Victoria, a map that stretches the breadth and depth of our state, from the Aboriginal rock art at Garryword in the Grampians to the Buchan Caves in East Gippsland. Last Tuesday, I had the immense privilege of visiting another part of our state that holds distinct importance. Located on Wurundjeri land, Corranderk was the home to the former Corranderk Aboriginal Station. I was welcomed by Commissioner Sue Ann Hunter, who has a deep connection to this place. It was established under the auspices of the so-called protection policies. In reality, it's a place where First Peoples' lives were dictated and controlled. And despite this, and indeed in the face of this, Corranderk's residents resisted. One of the many acts of resistance that speak to Aboriginal people's enduring strength and survival. Today, Corranderk has become a site of cultural revival. Babies are welcomed to country, and coming-of-age ceremonies have been reawakened after more than 180 years of colonial suppression. Sitting alongside Commissioners Burke, Hunter and Walter and speaking to some of the young women there, they told me what it means to be able to practice their culture on country again, what it means to be able to pass that on to their babies and children. I wanted to make special mention of Corranderk and those women because I think it says something powerful about First Peoples' resistance, but also about the purpose of treaty and truth in Victoria. There are many reasons to tell the truth, and I'm sure just as many perspectives on what those reasons are. But for me, the purposes are threefold. Truth matters to our past, our present, and to our future. It matters to our past because still the record of our state's history is incomplete. Like many Victorians, my formal education of Aboriginal people's histories and experiences was limited. To be clear, that limitation was not an accident, an oversight or absent-mindedness. It was part of a deliberate and systematic attempt to erase First Nations people from our state's history. To somehow cross out tens of thousands of years of connection to country, to blot away the bloody stains of colonisation. The process of truth-telling is a refusal to submit to that silence. The record this Commission will hand down will mean at long last the truth of our state's history is told. The murder, the massacres, the dispossession of culture and country, the land taken away, the way of life destroyed, the children who never came back home, and those who are still trying to find their way back. I also want to acknowledge that it's not enough to merely know this history. We do need to learn from it, and we need to act on it too. Because as the work of the Commission has made very clear, our history continues to live on in our present. And I want to acknowledge there is an unbroken line between the dispossession and violence of the past and the lives of First Peoples today. I also want to acknowledge and put very clearly on the record that from the beginning until today, the policies and practice of government have created the gap that exists between Aboriginal and non-Aboriginal Victorians. Whether ignorance or deliberate intent, we have driven that disparity. And as the Commission has noted, that disparity continues to play out in the lives and life outcomes for Aboriginal people. Acknowledging that ongoing injustice demands an honest recognition that despite efforts and intentions, we still have a long way to go. And it's the reason why we are here today. As Premier of this state, I come to the Commission with purpose. I'm committed to truth, treaty and self-determination for First Peoples. As Commissioner Burke said, this process is not about making any one individual feel guilt or shame. Instead, it's about reckoning with our past, being honest about our present, and reaching for a better and fairer future for First Peoples. And that begins and ends by listening. To me, it's pretty much common sense that when you listen to people, you get better outcomes for people. And if truth is about listening to First Peoples' experience of injustice, then treaty must be about listening, genuinely listening to how that injustice can be addressed and working together, empowering First People to address it. I look forward to your questioning today. Thank you.
Thank you.
Thank you, Premier. Now, you have assisted the Commission by preparing a statement dated the 18th of March 2024. You've had the opportunity to read over that document.
Yes.
And you're satisfied that the contents of that are true and correct to the best of your knowledge?
Correct.
Commissioners, I tender the statement of the Honourable Jacinta Allan MP, Premier of Victoria. The document will be given a document number in due course. Now, Premier, I just want to ask you a question about your opening statement. Of course, you're here as Premier in your official capacity, but is it fair to say that the opening statement disclosed some level of personal commitment to the truth-telling and treaty processes that we're all involved in?
Yes, it does.
And can you explain for the Commissioners what that level of personal commitment is on your behalf?
My personal commitment is built both through the time I've served as a Member of Parliament. I mentioned in both my witness statement and in my opening remarks, I'm very proud to call Dja Dja Wurrung country home. It's the place I was born and grew up in, raising my family in, and have a deep connection to the community and to the area. And through my time as living there in beautiful country, but also too as my role as a Member of Parliament, I have come to learn the history of our state that I wasn't necessarily taught during my formal education. Being of a generation where First Peoples culture and connection to country wasn't celebrated, as I said in my opening statement, it was one that was largely erased from the education of my time. And so it's working through the process in preparing for today's hearing as my role both as a Member of Parliament and now in various roles as a Minister and now Premier. It really does come home to me just how critically important treaty is, given that history that has not been told, given the history that must be told, but given how we also must take the opportunity to work towards treaty, because as Commissioner Lovett mentioned, the international evidence is there. Treaty is what makes the change. Treaty is what rights the wrongs of that initial dispossession of colonisation. And it is with the learnings that I have come to through this process and my own work as a Member of Parliament that I bring that personal commitment to treaty process today and on behalf of the broader government.
Thank you, Premier. As you've just stated, the opening statement, together with the statement you've prepared for the Commission, also demonstrates that you have taken with the utmost seriousness your role as leader of the state and leader of the government. Can you explain for the Commissioners, just in brief terms, why it's so important that this process is led by the leader of the government?
It gives an unequivocal, sends an unequivocal message that government is determined to be partners through treaty process to bring about the change. And that is particularly important in a time where these questions are challenged by others, that I, on behalf of the government, and I must say with the absolute commitment and support of my colleagues, that we continue to demonstrate through our words and actions, and I acknowledge they are actions that still have some way to go in terms of addressing the historic wrongs and working towards the treaty outcomes. It makes it very clear that government is resolutely determined to work with First Peoples to achieve treaty in this state.
Thank you, Premier. If we might see document number 1 on the screen. Premier, when you became the leader of the government on the 27th of September 2023, you identified housing and treaty as your priorities. Can I ask what influenced the identification of treaty as a priority that should be named in what was your very first media interview as Premier?
I wanted to make it very clear in my very first opportunity as Premier in September of last year to make it absolutely clear that I had that ongoing commitment and determination to work with First Peoples to achieve treaty. It was a time last year where there was much debate about these matters, and I wanted to put it absolutely firmly on the public record that my commitment to treaty was unwavering, and for there also not to be any opportunity, for there to be any hint of a doubt both for First Peoples, but also too for those who want to sow seeds of doubt, that I was determined to carry forward the work that had been done before me in this role, but also recognising at the point in time that I was stepping into the role, we were coming into the land justice hearings for this session of Yoorrook, and also too we are working towards the treaty negotiations commencing potentially towards the end of this year. So I recognise that it is a very critical and precious time for truth telling and treaty, and I wanted to make it absolutely beyond doubt of my firm commitment to truth telling and treaty.
Thank you, Premier. Then in December 2023, following the defeat of the constitutional referendum question in relation to a First Peoples voice to Parliament, in October 2023, you again spoke in the following terms. If we could have document number 2 on the screen, please. You spoke in the following terms. In Victoria, we are some ways well ahead of the voice, he said, noting the state had already enacted the voice and truth aspects of the Uluru Statement of the Heart via the democratically elected First Peoples Assembly and the Yoorrook Justice Commission, which oversees the state truth-telling process. Now, those comments were recorded in a piece in The Guardian on the 9th of December 2023. You recall that particular piece?
Yes, I do.
In the shadow of the referendum loss, how important was it for you and your government to maintain the commitment to this process?
Again, I wanted to make it clear that we were unwavering, if you like, in terms of continuing on the path that was set prior to the conclusion of the voice referendum last year. But also I made those comments in the context of having spoken to a number of First Peoples following that referendum outcome, and I knew that there was a lot of hurt, a lot of concern, and I wanted to make it absolutely clear that despite that result, we wanted to continue on the pathway we had already set. And we had already set that pathway because the evidence tells us that it is the treaty pathway that gets better outcomes through listening and telling the truth, which obviously this process is a critically important part of. But working to treaty and the outcomes of treaty and having a true self-determined approach for First Peoples was the way to get those better outcomes that we also want to see. And it was in that context at a time that there was a lot of and concern in the community and some questions and understandable questions that I wanted to make it absolutely clear of our ongoing commitment.
In that article, you also recorded as having said, I am not going to come to the table wanting to prejudge the outcome, speaking about the negotiations. That's something that you've repeated in other circumstances, is it not?
Correct.
And can you just explain for the commissioners the thinking behind that statement?
My thinking behind that statement comes from a fundamental position of wanting to respect the process. We have established treaty process. We have established the negotiation framework and arrangements, having a negotiation table where First Peoples sit with government as equals to the process. We have our independent oversight with the treaty authority, and I'm wanting to respect that process, not put over the top of that process my own expectations and demands, because that would be entirely inappropriate in my view. The only position I want to make clear is that we, in terms of being fully supportive of treaty outcomes, I want to see an outcome, and the timeline and what is contained in that outcome will be determined by those with the responsibility and the accountability at the negotiation table to deliver that.
Premier, I would just ask you how strongly wedded you are to that position of respecting the negotiation process. Clearly, there's the potential for, even from this evidence today, for questions to be put to you about ruling certain things in and out of on the negotiation table. Can you make any comment in that regard to the commissioners?
I've on many occasions with all due respects to our friends who might be watching this from the media side of the table, on many occasions I've been asked to rule things in or out in terms of what may be discussed at the treaty negotiation table. And I'm simply not going to do that because, again, that would be disrespecting the process. It would not be adhering to we have empowered our representatives, the First Peoples representatives, the government representatives. We have empowered them with the tools and the authority to negotiate on our behalf. And I am not going to undermine their work by giving what at times may be seen very binary answers to questions when I'm performing other public duties and being asked questions about treaty. I think that would be deeply disrespectful to those who have the responsibility on our behalf to negotiate the outcome.
Thank you. Premier, I might at this stage take the opportunity to show you and those watching the terms of reference. If we could see the terms of reference for this commission on the screen, please. Firstly, if we could zoom in on the background. First three dot points of the background, Premier. Firstly, we all understand the historic nature of this commission having been created to investigate the injustices of Victoria's past and the ongoing injustices, and we note that other states appear to be following suit. But it is important that we understand the actual terms of reference for this commission. At background, the first three dot points indicate that the First Peoples include the traditional owners of the lands currently known as the state of Victoria, over which they maintain that their sovereignty was never ceded. First Peoples' experience of colonisation have included grave historic wrongs and past and ongoing injustices and intergenerational trauma. The state of Victoria acknowledges both the continuing impacts arising from historical injustice and the ongoing strength and resilience of First Peoples and survival of their living cultures, knowledge and traditions. So that sets part of the framework. The background goes on, but if we could turn now to item 2A. Thank you. So at part 2 of the terms of reference, we have the objectives, and the objectives of the Commission are said to include, it goes on for a number of subparagraphs, but it's said to include to establish an official public record based on the First Peoples' experience of systemic injustice since the start of colonisation. So that indicates to this Commission and to the world at large that we are to start from the beginning of the impact on First Peoples in this continent. You would agree with that?
Yes, I would.
Then if we go to objective 2B, it goes on, the objectives of the Commission are to develop a shared understanding among all Victorians of the individual and collective impact of systemic justices and the intergenerational trauma that has flowed from them since the start of colonisation. And so it is in creating that shared understanding that we are all seeking to ensure that the evidence allows the appropriate findings. You would agree with that?
Yes, I would.
If we could go to paragraph 3A, subsections 1 to 4. Thank you. So the terms of reference of the inquiry are that having regard to the objectives set out above and subject to the Inquiries Act 2014, you are appointed to inquire into and report on historical systemic injustices perpetrated by the state and non-state entities against First Peoples since the start of colonisation, including but not limited to, and I'll just take you to the first 4 of those, Premier. Cultural violations such as breach and denial of First Peoples law and law. 2, theft, misappropriation and destruction of cultural knowledge and property. 3, eviction, displacement and dispossession. And 4, massacres, wars, killing and genocide or other acts of similar gravity. So you can see that that in commissioning this inquiry to undertake the work that it's doing, the government did not shirk some of the difficult issues that are going to be faced in exposing the truth. You accept that?
Yes, I would accept that. And it was the only way to get the truth.
If we could then turn to paragraph 3B6, please. So the second part of the terms of reference are ongoing systemic injustices perpetrated by state entities and non-state entities against First People, including but not limited to the areas of, and at subparagraph Roman numeral 6, any other ongoing systemic injustice considered appropriate by the Royal Commission. So that indicates to this commission that its fiat is very broad, and the important fact is trying to identify the injustices and any injustices that occurred to First Peoples are within its fiat. You'd agree with that?
Yes, I would.
Thank you. Just briefly, if we could go to 3D and E. Thank you. 3D provides how historical systemic injustice can be effectively and fairly acknowledged and redressed in a culturally appropriate way. So this commission is given the task of dealing with the appropriate redress as a result of those injustices. You'd agree with that?
Yes, I would.
And E, how ongoing systemic injustice can be addressed and or redressed, including recommended reform to existing institutions, law, policy and practice, and considering how the state of Victoria can be held accountable for addressing these injustices and preventing future injustice. And you accept that that's appropriate for this commission?
Yes, I do.
Thank you. Now, you will understand from your briefings, we expect that the evidence before this commission makes clear and undeniable that First Peoples were murdered in large numbers, that children and women were stolen and raped and tortured, and this was mostly done so that First Peoples' lands could be taken. You're aware of that from your briefings in relation to these hearings?
Yes, I am, and I go to some of those examples in my witness statement.
And these facts I put to you, Premier, are facts that are very well known to First Peoples in this state, but I suggest to you are mostly unknown by non-First Peoples, including government officers. Would you agree with that assessment?
Yes, I would.
Whose responsibility then is it to educate the broader community about these matters?
It is absolutely the role for government and the various organisations and arms of government to be able to tell this version of history. And again, I think Commissioner Lovett made some of these remarks when we were at the welcoming ceremony outside this morning. And Council assisting, as you have identified through the terms of reference for this commission, a critically important part is making sure the truth is not just told and acknowledged and understood, but having the record written, the accurate record written, so that we can then have the foundation on which we go forward in understanding the colonisation and what was done in the name of the colony, what was done not in the name of the colony as well, and what impact that has had today. Because until we understand that, and it's not just an academic understanding, and I think if the Commission may, it's not, there's the academic understanding, and there is much that has been written, much that I have learned from those reports in preparing for today, but it is making sure that it's understood across the community more broadly. It's about understanding why, when they're in local communities, why there are concerns about the gold royalties that have not been returned to First Peoples. It's about understanding why rates of child protection removals are higher. It's understanding where that disadvantage started from And I think Commissioner Burke talked about that unbroken line of injustice in your opening remarks today. It's understanding that both at an academic level but also at a personal level, so that that true history of our state can be told. And in my personal view, not enough of us know that story. Not enough of us know that story, and it is again, in my witness statement, I refer to that there is more to do in our education systems to make sure that this truth, this historical truth of the record that will come out of the Yoorrook hearings in the future is told through our education systems going forward.
Could I just ask a question? Is there a genuine appetite to in education to make contemporary curriculum and tell the truth? For example, using materials from this commission, because we are getting so much material, so much information about the present and the past. And I just wonder if you have an appetite for this, in addition to treaty or separate from treaty, as a mainstream thing.
I most certainly do. And Commissioner, I'm not wanting to preempt or anticipate your own recommendations back to government that you may make on this front. I've just found personally the material that the Commission has put on its website, the video clips and that tell the story of the impact of those first settlers around the Portland area. There is a number of really, really informative pieces of information that you are already providing to the community. Out of today, it would be wonderful if more people went and sought for themselves this information, but also too, I'm conscious that there is a role for government to enable that, to lead that, to guide people to find out this information, and then look at how we can embed to embed the historical record in our education systems. I'm already seeing how our education system today is very different to the one that I went through in terms of what kids at the youngest of age learn about First Peoples culture and practice, and even conversations at the earliest of years of schooling about land dispossession. We can build on that. The work of this commission will give us an enormous wealth of material and evidence and fact that we can then look at how we embed that more broadly into our curriculum.
Thank you, Premier. Again, without preempting the findings and recommendations of this commission, there would be a number of ways in which the government could ensure that this information is not only known but embedded in the community, and the history of the state is no longer a contested space, which First Peoples have to recontest every time they wish to campaign for their rights.
Absolutely.
Now, Premier, I now wish to take you to your statement and paragraphs 3 and 4 of that statement. We know that you made these comments also in your opening, but could you please, for the commissioners, read paragraph 3 and paragraph 4?
I acknowledge that sovereignty was never ceded and that the impact of dispossession and colonisation on Aboriginal peoples is still felt today. I acknowledge that traditional owners' spiritual and ancestral ties to their lands and waters can never be extinguished.
In relation to paragraph 3, you accept that there has never been a transfer of sovereignty from First Peoples, what is now referred to as Victoria, to the state of Victoria or its predecessors?
Yes, I do.
With respect to paragraph 4, you acknowledge traditional owners' spiritual ancestral ties to their lands and waters can never be extinguished. Are you making a distinction as to as between spiritual ancestral ties and legal ties by the use of that wording?
The wording of that paragraph was intended to acknowledge that alongside the impact of dispossession from land, and I would include water in that, in terms of the connection of land and water and how it relates to wealth and the transfer of wealth. It was also to acknowledge the spiritual and ancestral ties alongside that as well were not extinguished.
Yes. You understand, though, that in the laws of most First Peoples around Australia, those spiritual and ancestral ties are the basis for rights of ownership and possession of their territories. You understand that?
Yes, yes, I do.
And indeed, it is those spiritual and ancestral ties which are the foundation upon which continuing native title rights and interests are recognised by the common law.
Yes, yes, I do.
And at paragraph 24 of your statement, Premier, you observe, and might I say, you express your pride in the extent of Aboriginal cultural heritage in this state, and the fact that there have been some 43,000 sites recorded across this state, cultural heritage sites. Can you consider for a moment whether, in your mind, that there is any doubt that First Peoples have occupied and owned the whole of the state of Victoria for a very, very long period of time?
Yes, and in acknowledging that sovereignty was not ceded, that is an acknowledgement of that connection.
There is also no doubt, I suggest to you, that over that period of time, First Peoples have exercised a connection of extraordinary spiritual, cultural and ecological depth. Would you agree with that broad proposition?
Yes.
Do you agree that the depth of that connection was historically and remains largely ignored or at best misunderstood outside First Peoples communities?
Yes, and the engagement the Commission and I have just had, I think, speaks to that and speaks to the importance of making sure that the record out of this process is further embedded in our community's understanding.
Yes, indeed. As one example of many, we had evidence on Friday the 26th of April 2024 from a group of 4 First Peoples, John Clark, Matthew Shanks, Catherine Muller and Mick Burke, speaking about their deep connection to country exercised through fire management. And I'd ask you to accept that those very ancient skills and the knowledge that's relied upon for fire management have been throughout the history of this state, at least, dismissed or not valued until very, very recently.
Yes, I would. And I think in terms of your reference to very recently, it has been in, I'd say, recent decades that there has been work particularly around the use of cultural practice in fire management and fire protection for communities has been something that has been a very important step forward for protecting communities that are in those more fire-prone areas of the state, including the one I live in as well.
Now, I propose to ask you a few questions about your understanding of the notion of First Peoples self-determination. But before I do, I might ask whether the commissioners have any questions in relation to the questions that have been asked so far. Thank you, commissioners. Premier, at paragraphs 36 to 38 of your statement, you discuss your understanding of self-determination. Particularly, I draw your attention initially to paragraph 36, where you indicate that self-determination became a key principle of First Peoples policy in 2015, and then embedded into the commitment to treaty in 2016. Is that correct?
Yes, it is.
And as a result of that, commitment to self-determination as a key principle, there have been a large number of policies and framework and statements that have been developed in order to come to terms with the notion of self-determination by government. You'd accept that?
Yes, I would.
In your view, has the adoption of the policies in relation to self-determination brought about a noticeable effect in government in the way that it deals with First Peoples?
If I can answer that question in two parts, and I'm particularly pausing on the use of the word noticeable. I would say in answering that in two parts, I would say it has made an effect. I would say acknowledging that we still have quite some way to go, and I'm grateful for Commissioner Lovett's presentation to a cabinet meeting last year for ensuring that we had a much better and stronger understanding of the principles of self-determination and how it's not just to talk about them, but how to put them into action and practice. So I would say it has some effect. I'm pausing over the use of the word noticeable because I do want to acknowledge that we have quite some way to go, that there are many parts of government that are showing a good understanding and good practice of self-determination. Then there are others that are making good endeavours but are perhaps not fully acquitting the requirements in terms of understanding that to achieve self-determination, it's not just consulting, it's making sure that it's that transfer of and sharing of power and resources, making sure that that is embedded in the work we do. But I would put to the Commission that the very noticeable effect that our framework on our policy principle of self-determination sits in our commitment to treaty. Treaty is very much the embodiment of self-determination, and that is perhaps the most notable effect that policy has had on the decisions of government.
But it's the case, isn't it, Premier, that you're not saying that because the state is moving ahead on treaty that everything else goes on hold?
Absolutely not. Absolutely not. And I'd be concerned to hear that there was evidence or reports to that effect, because and I don't want to be stepping into the shoes inappropriately into the shoes of First Peoples, but again, the references today to 236 years of colonisation have spoken, and the time it's taken to get just to this point here in Victoria, in Australia, speaks to the fact that it has taken a lot of time to get to this point. And whilst we work through truth-telling and treaty, we need to make sure that along the way, there are particularly those key areas of government administration that is having an ongoing impact for First Peoples, that we continue to work very hard to embed the practice of self-determination into the work we do.
I mean, in fact, the evidence before this commission has been consistently disclosing a failure to deliver on the policies, programs, strategies and frameworks that have flowed from the self-determination policy. And it's a matter of particular concern to this commission, as you could imagine, Premier. Are you saying that the lack of performance is not something that's been brought to your attention, or is it is something that you're aware of?
It is, just to be clear, Commissioners, it is certainly something I'm aware of. I've had the opportunity both to watch and read some of the evidence that has already been given to this commission, and I have heard and seen this line of questioning and response. So just to be clear, no, this is not the first time I'm aware that there is a lot more work for government to do in working through embedding the principles of self-determination across the work we do.
Well, clearly, though, the delay or failure to implement plans and strategies and frameworks raises a number of issues. The first for this commission, which was alluded to by the chair in her opening remarks, is the concern that this report, this final report from this commission, will be yet another report that is added to the pile and then not acted upon. What can be said, if anything, to give the commissioners comfort that that's not going to occur?
In answering that, I do wish to point to that this that our truth-telling process that I'm participating in today and government is participating in is part of that treaty process, that we have set the path towards treaty that, if I could put it this way, government can't duck out of its responsibilities to treaty. We have legislation that requires us to come to the negotiation table. We have a legislative framework. We have the obligation and the personal commitment as well. I want to be clear that it's not just the legislative requirements that we're undertaking this. It's because it's the right thing to do. But I do point to the fact that the work of this commission is directly related to treaty negotiations, and that there will be a requirement for government to respond. And I do acknowledge the Commission's concern at the government's response to its previous report. And I say that we understand that concern. I understand that frustration. I do point to a number of the recommendations require a lot more policy work and thinking of government, because some of the recommendations do challenge some of the policy positions we already have as a government. It does require us to take time to consider those positions that have been put to us. But ultimately, the treaty process is going to be the one that holds the government to account on recommendations and reports that come through this process.
There's no legislative obligation to act on the recommendations of this commission, though, is there?
There's no specific legislation that goes to the reports of this commission, other than that it has been very clearly established as being an integral part to treaty. And again, the international evidence shows us that to achieve treaty that can support better outcomes going forward, we can't do that from a position where the clock starts as you sit to the treaty table. The clock started 236 years ago with the colonisation of this state and that dispossession of land, and understanding that impact that has an ongoing, that dispossession that has an ongoing impact in the disadvantage that we see today.
You can understand, however, Premier, that amongst the other concerns about the non-performance that's been the subject of evidence in this commission, that the commissioners might properly be worried about whether the state and the agencies of the state can make the shift in culture that is necessary to fully embrace the notions of self-determination. You understand those concerns?
I most certainly do. And as this has been referenced this morning, other ministers, other representatives of government who've been before this commission before me, I think it demonstrates that to bring about this change will require deep cultural change within government, both our own practices and structures and how we go about the business of forming policy and developing policy and having our own deliberations. But also too, it will also challenge, and Councillor Assisting, you went to this earlier, some of the views of people in our government systems as well. So this work will be deeply challenging and complex to turn around, but treaty, I again come back to the central importance of treaty as requiring that change, demanding that change, that we have to acknowledge that it's hard, it's going to be complex, but we have to push on. We have to push through these complexities. We have to work our way through, and a large part of that sits with our negotiators at the negotiation table. But I also am deeply aware of the requirement for government to also work through its own challenges in being able to come to working through these issues in a very different way to what we do at the moment.
Many First Peoples who have given evidence to this commission have expressed the view that what they see occurring or not occurring today, in their view, is just a continuation of that which has happened in the past. Premier, have you heard the expression "another day in the colony"?
Yes.
You understand what that expression means?
I have my understanding, but it'd be
Well, perhaps you could share that understanding with the commissioners.
It goes to, I believe, what the Commissioner Burke said earlier. Oh, sorry, it might have been Commissioner Lovett talked about crumbs from the table. Commissioner Burke talked about another report. It's another way of describing business as usual. Another day in the colony is business as usual. Government goes about its business, and the ongoing dispossession and injustice for First Peoples continues. And this is why treaty is, again, I appreciate I've mentioned this a few times already this afternoon, is so deeply important to bring about that change.
You might be required to say it a few more times today, Premier.
I think so.
Before we finish. Do you accept, and I put this without wishing to be overly dramatic about it, Premier, but do you accept that a shared understanding of self-determination for First Peoples in Victoria is a matter of survival? Do you accept that proposition?
Yes, I would.
By that proposition, Premier, it's meant to say that First Peoples in Victoria often exist in circumstances where, well, they do exist in circumstances in Victoria where they are not the dominant culture. They have little or no power at the ballot box, and they have little other influence, and are generally subjected to the whim of government, and have been so since the beginning of the colony. Do you accept that broad description?
Yes, I would.
How then do First Peoples get past a self-determination that is understood by government, as it appears to the Commission from many of the witnesses, that is understood by government as something that government can measure and control and design programs for?
Well, in my view, that would not be consistent with the principles of self-determination. It would not be consistent with wanting to truly bring about change through treaty process. The understanding that self-determination, as I understand it, the true principles of self-determination is not for government to go away and do its own business and still be a consultation here and there. It is about making sure that it is about transferring decision-making and power. The ultimate embodiment of that is treaty. And so I would say back to you, Councillor Assisting, that the self-determined framework that we have is not one that's determined by government. It's informed by the principles of self-determination and the advice of First Peoples in setting that policy framework.
And so Victoria as a state, including its government agencies, I suggest to you, if they are to fully embrace the principles of self-determination, must get to a point where those principles are recognised as embedded rights within the culture and work of government on a day-to-day basis. Do you accept that?
Yes, I would.
And so on the 26th of April, 2024, which is last Friday, Professor John Burrows from the University of Toronto, an expert in First Peoples self-determination, observed that government and community can be brought to a better understanding of self-determination through truth-telling processes such as this process. That was his evidence, and he spoke about similar processes in Canada which had a positive effect in raising the understanding of self-determination. Clearly, from your evidence thus far, you have hopes and expectations that this particular truth-telling process will have that type of effect for the community and government here in Victoria?
Yes, I do.
Is it the case that the government understands that there may be it may be appropriate for there to be further truth-telling processes undertaken at a more local or regional level to take this level of understanding out into the community?
Yes, it is. And if my memory serves me correctly, when I had the opportunity to meet with the commissioners earlier this year, we had a discussion along this line. Again, I'm not wanting to cut across any future advice from this commission, but I also think it's referenced in the terms of reference for the work of this commission to contemplate future and ongoing truth telling. But I will seek and wait the advice from the commission on that matter.
Thank you. I just want to turn now to some questions in relation to your visit to Corranderk. You went to Corranderk on Tuesday, the 23rd of April 2023, and you spoke about that visit in your opening remarks this morning. You have also discussed Corranderk in your statement at paragraph 40, if we could see that on the screen, please. You characterise in your statement the 1881 parliamentary inquiry into Corranderk as a form of truth-telling. But at paragraph 45, you then note that Corranderk was eventually created as a permanent reserve in 1884, only for the state to then pass the Aborigines Protection Act of 1886. Premier, this process of giving with one hand and taking away with the other is emblematic of First Peoples in this state and in other places indeed being political footballs at the whim of government. Would you agree with that?
Yes, I would.
And that it's your understanding from reading your statement that there is some significant hope that the entry into a treaty or treaties in this state will somehow protect First Peoples against the constant changing of political ideologies that occurs with the change of government.
It is certainly,
indeed, the change of minister.
That is certainly my aspiration, both through this truth-telling process and treaty negotiations.
In evidence, Premier, given by the Victorian Surveyor General in relation to Corranderk, there was a presentation of a series of PowerPoint slides from which it is plain that there were various attacks on the reserve in terms of attempts by non-First Peoples to close the reserve and to obtain the land on which the reserve sat, and that those attacks, those raids on the lands of the Aboriginal people at Corranderk, when viewed over time in the way presented in the PowerPoint presentation, show that this desire and attack on their lands was relentless. It happened year upon year over decades and decades. And it demonstrates, when one looks closely at it, a degree of insatiability on behalf of the non-First Peoples who were seeking to get the lands of the people at Corranderk. Do you have sufficient understanding of the history of Corranderk to comment upon that proposition?
Well, perhaps in answering that question, go to the broader theme of land and water that this set of hearings is part of, and it does speak to the connection of land to wealth, and that the white settlers came with a particular view that the possession of land brought with it wealth. And what we have also seen, conversely, that the dispossession of that land and the loss of that intergenerational connection to land hasn't just had an impact on First Peoples' culture and connection to country, it's also had that intergenerational impact of economic disadvantage that comes from not being connected to your land.
The material provided by the Victorian Surveyor General shows that piece by piece, Corranderk Reserve was reduced in size to allow other people to take that land for their own, including through soldier settlements. And you've already discussed that, as has have the commissioners. But you would agree that it is a bitter irony that not only was the size of the reserve reduced, but it was reduced in order to provide land to a soldier settlement scheme to which First Peoples returned servicemen were denied access to. You agree with that?
I agree, and agree that it's shockingly wrong and unfair.
As I put to you a moment ago, the dismantling of Corranderk discloses a relentless and an insatiable demand for land. But it's not simply the fact that non-First Peoples, Victorian people, were relentless in their desire for the land of the First Peoples at Corranderk. The facts of that dissection of those lands also speaks to government facilitation of that dispossession. So even though there were individuals pursuing those pieces of land, it was the government whose hand actually facilitated or made the order for the cutting up and sale of those lands. You accept that?
Yes, I would.
And the process of facilitating the dispossession of First Peoples in order to provide land to British and then Australian people has been a part of this state ever since the first arrival of the Surveyor General and the Lieutenant General in Port Phillip Bay and the creation of the Port Phillip settlement. You agree with that?
Yes.
Well, I want to take you now to paragraphs 81 to 86 of your statement. If you could just turn there, please. At those paragraphs, you outline some of the observations made about First Peoples in Victoria in the period 1830 to 1840. You accept, Premier, that by the time of that colonisation in the 1830s, particularly following the Burke Proclamation in 1835, the British government and indeed their appointees in the colonial government in New South Wales, the Governor and the Legislative Council, they were all very aware of the likely outcome of colonisation for First Peoples. And I put that to you on the basis that they had been involved in the expansion of Sydney into the 19 counties at the expense of Aboriginal people there, and the horror, the absolute horror of what occurred to people in Tasmania in the period 1800 to 1820. So they knew that fatal and broad spread death would follow from their opening up of the Port Phillip Bay settlement. Do you accept that?
Yes.
I put this to you because they are matters of public knowledge, and I understand, Commissioners, that the Premier is not a historian. You're not a constitutional lawyer either, are you, Premier?
I know.
No.
There's
so
only a few of us who have that opportunity.
So you accept, though, that it's a matter of public knowledge and within your knowledge that this consequence of the invasion and occupation of the lands of First Peoples was also known about because of what had occurred in North America, in what's now known as the United States, and in Canada, in the West Indies, in South Africa. It was not a new phenomenon.
No, it most certainly wasn't. And it appears that the British government of the time appeared to understand that, which is why, from again my reading of history on this and in preparation for today, why there were grave concerns about what was happening in the then colonies of the time.
You'll be comforted to know, Premier, that the historian experts that have given evidence agree with your view. Knowing that death, dispossession, and all that entails would follow from the occupation of First Peoples lands in what is now Victoria, I suggest that places a particularly heavy moral and legal duty on those involved at the time to protect those peoples.
I would agree with that suggestion, and it is, to me, it is unfathomable as to why it wasn't that path was taken.
And indeed, there is some very heavy moral and legal duty that now passes to this government and successive governments to ensure that that you do whatever is reasonably possible to ensure that there is some restitution made for the terrible offences against First Peoples in this place.
Yes, I am deeply aware of that. I think, Councillor Sitting, as you put them, I think you said the moral and legal duty that passes on to those of us who today represent the government and the institutions that make up the state of Victoria, and the responsibility we have given the past practices and decisions of those at the time.
And indeed, Premier, at paragraph 67, you first line, you note that you found the evidence of the way in which First Peoples were dispossessed from this place distressing. Can you explain to the commissioners how it is that, in particular, you found it distressing? Was it distressing as a government officer, distressing as a parent, distressing as a human? What was the basis for your distress?
My distress came from all of those, but most particularly as a human, as I've said in my witness statement and on previous occasions. I have learnt much that I did not know in terms of the true history of the dispossession, what the settlers, the colonisers did when they came to Victoria. I did not know of the massacres, I'm ashamed to say. I have learnt about the size and scale of the murders and the massacres through my preparation for my appearance today. And I remember a few weeks ago now, as I was preparing the materials for my witness statement, and I've mentioned a few times I live on Jacinta country, and it's beautiful country, and I live in an area that's surrounded by the bush, and I was sitting there in my backyard reading through the materials and just felt so distressed that these were massacres that occurred not far from where I was sitting, and I didn't know about them. Growing up and living as I have all my life in central Victoria on Jacinta country, I did not know about the massacres that occurred so close to home. And that is what that distress carries with me today. It brings me a sense of shame and distress personally that I did not know that. And it brings me a sense of shame and distress that this was done. This was done by people all in the pursuit of taking land off First Peoples, and as an extension of that, as council assisting, to know that the consequence of that was the impact of death and dispossession for First Peoples going forward.
I mean, if you could turn to paragraph 99 of your statement. In that paragraph, you say, I recognise that the frontier period from the 1830s to the early 1850s was a period of conflict in which violence was widespread. This included First Peoples' resistance to settler encroachments on their land in the form of taking sheep and sometimes killing settlers, as well as settlers and colonial authorities killing First People. And putting that in your statement, those words in your statement, you're not seeking to diminish or in any way discount the fact that the overwhelming result of the invasion of First Peoples' lands was the death of First Peoples. Are you not seeking to walk away from that?
Most certainly not. Most certainly not.
It seems worded as it is that it's put by way of some explanation for the reprisals that Aboriginal people were taking settlers' sheep, and they were sometimes killing settlers, and therefore it was a bit of to and fro. Is that what you intended to convey?
No, council assisting, it most certainly is not, and it was an attempt, and perhaps a clumsily worded attempt, to again tell the truth, tell the history of what occurred at the time. As I say in that at the end of that paragraph, many more First Peoples were killed than settlers. What I was endeavouring to present was the conflict and the consequence of conflict. I absolutely acknowledge that First Peoples did not invite or did not want this conflict, and that the response of First Peoples was one that, at a time of, and again, I think Commissioner Lovett, you might have mentioned this in terms of, or Commissioner Burke, referring to the noise of gunshots, that never heard that before. And so I do not wish this to be seen as anything other than an acknowledgement that there was conflict at the time, and that the conflict was centred on settlers seeking to dispossess First Peoples of their land.
I could ask you to turn to paragraph 81 of your statement, please, Premier. That paragraph, you say employees of the British government reported numbers, paraphrased, reported numbers and the best ways to protect them, First Peoples, from the violence of colonisation.
Sorry, council assistant, can I just confirm the paragraph you're referring to?
81.
Yes. Okay, thank you.
So it starts in the 1830s and 1840s. Employees of the British government observed numerous Aboriginal groups across the region and reported to authorities to build a picture of their numbers, language, practice, areas of occupation, and ways to best protecting them from the violence of colonisation. The first observation about that paragraph is that the British government knew that Aboriginal people had areas of occupation, and that people weren't wandering in a nomadic fashion at vast distances across the landscape as was used to perpetuate the myth of terra nullius. You accept that? Yes,
I do. And I think further on in my witness statement, paragraph 85 refers to the ash hills as evidence that there was an ongoing connection to that land.
And the second observation I'll make, and I suspect it is a matter that requires only some clarification from you, but the reference to employees of the British government observing numerous Aboriginal groups is I suspect an attempt to be accurate and not an attempt to distance this Victorian government from the the activities that were undertaken in the 1830s and 1840s.
Correct.
The Victorian government accepts responsibility for that period.
Yes, insofar as the continuance of the state, obviously, that period that my statement refers to goes back to when it was the colony out of New South Wales, but I'm agreeing with your statement of ongoing responsibility.
And indeed, the state of Victoria has received many, many times over the benefits of that process of dispossession, has it not?
Yes, it has.
There's the commissioners. There's one more question that I've got for the Premier on this particular topic. I can then launch into a new topic, or we could take a lunch break. I'm suggesting that the lunch break be kept to a period of 30 minutes to accommodate finishing the whole of the Premier's evidence. I'm in your hands, Commissioners, as to whether you wish for me to continue on after this question, or that we break shortly.
Need to break, yes. We said break shortly.
Thank you, Commissioner. Now, Premier, noting again that you're not a historian by trade.
No.
One of the chief difficulties in developing an accurate historical record, I suggest to you, is the inability of First Peoples to obtain access to the documents held in the various archives in Australia and in Britain. Will the state, if requested by Yoorrook or indeed the First Peoples Assembly of Victoria, work with those groups to obtain access to all the relevant colonial records, including those held in Royal Archives and the records of the Royal Marines and the British Navy and the colonial officers?
Should the Commission provide recommendations to that effect, we would absolutely work with the Commission and relevant agencies, and it's consistent with the approach the government has taken in some other areas on this front. But absolutely, noting, I'm sure Councillor Assisting, you'd note this as well, that the historical record will will not necessarily always be the First Peoples version of what occurred at the time. There were some observations made earlier about who writes the record of history, and that being those who have the power of the time, but absolutely acknowledging the importance of these documents to continuing to understand the true history of the impact of colonisation on this state. Then yes, we should absolutely have access to those materials.
I can share with you, Premier, an understanding of what some of the difficulties are in relation to the historical documentary record. In this country, there is was an asserted occupation of Port Jackson, of the penal colony, by the British, and the original document can't be found. The original instructions and drafting instructions and commission of Governor Burke, who issued the Burke Proclamation, can't be found. And there are a whole string of very important documents which set out the history and the formation of this particular colony that are missing from the records of a people who are renowned for their record keeping. And so it is not a request made in slight terms that the government take on this role of pursuing the gathering in of these important documents. And so the question was put in that context. Does that make the question clearer, Premier?
Oh, yeah, it was previously clear, but yes.
Thank you. It might be an appropriate time now to take the break, unless Commissioners have questions about the topics that have just been covered.
Can I just ask one question from you? You've mentioned a few times in your statement or speaking in preparing for your statement that you found one, it's distressing, but also the history. And in line with, I guess, Commissioner, the Chair Burke's question earlier, do you think it's okay that this later in life, finding out this history, not too late, I'd add, but finding out the history of this state that late, that's okay?
No, it's not, Commissioner Hunter. I mean, in terms of, obviously, I had not a knowledge that many would have in our community of colonisation and how the state and the nation was formed. I have a broader view that there's not enough broader understanding of our political and parliamentary and our history anyway. But going to the question of the history of First Peoples and the dispossession, as I said earlier, the understanding of the violence particularly was not one, and I had a sense of it, I had a knowledge of it, but not how widespread it was. Not and particularly to the coming from central Victoria, my knowledge of what happened around Portland has been deepened by preparing for this witness statement today. And I reflect on the greater depth of understanding I have now and how that benefits me as a person, let alone in my role as Premier and a Member of Parliament. I think we can all benefit from understanding that history.
Yeah, going back to the earlier topic of the many strategies and frameworks, and we have literally seen dozens and dozens of these concerning First Peoples, all of them full of laudable and indeed lauded commitments and obligations, and none of them, to my knowledge, that we have seen here, which have actually delivered on those. When you talk about a change of culture in the public service, how will that happen if there are no consequences? And there does not appear to be for any of these consequences for failure to deliver those commitments.
I mean, Commissioner, I think that speaks to why treaty is so important, because the practice to date clearly has not delivered against the outcome, has not delivered and has not changed the outcomes we're endeavouring to change. The reason for that can be in how those frameworks were put together. If they have not had those principles of a self-determined approach, then they are not going to have as much success as others would. I think there has been some areas where we have made improvements in some of the Aboriginal controlled health and housing organisations is an area I would point to. But it does demonstrate that we need to do so much more in both changing our practices within government as we deliver treaty with First Peoples.
Can I just ask a question following on from that one? And Premier, you might like to answer this after lunch, because it's, I think, one of the two issues that has really troubled me in sitting here now for a number of weeks in the land injustice part of the inquiry. There has been a really sad history of government policies being promoted and then not actioned. And your evidence seems to suggest that the answer to that history is treaty. My question is this, that if treaty is the answer, it means that there's been some assumptions made about what the reasons were for the failure to date that we've heard about. And I just instance, for illustration purposes, for instance, water is life in the water space, or the first principles review, where principles of self-determination are set out in the policies. And what is it that
cause those policies, which are now either expired or nearly expired, not to have delivered? Because until we know the answer to that, we don't really know the answer to why something else, namely treaty, should succeed. And I'm really struggling and have over these weeks to understand what has caused this position to arise. There've been some hints in the evidence, but I don't want to put you on the spot immediately, because I would really like some guidance about the sorts of things that have caused those failures, which will be mended by treaty. So I'll leave that to you. I'm sorry if I make your lunch a miserable
No. I
exercise.
welcome the opportunity to reflect on that over the break, and we'll return.
Yes, thank you.
In line with that as well, what can you articulate here? What is the government? So community are getting ready. First people are working without. What is the government, but more importantly, the bureaucracy, doing to get treaty ready on their behalf? They've got to come a long way, as we've identified through the lack of implementation of the Victorian Aboriginal Affairs framework and the self-determination reform framework. So I'd like to understand what is happening from your government, but also
Thank you.
If perhaps 155.
We'll adjourn until 1:55.
Is a commission.
Wait, that was right, wasn't it? 1:55, yes.
May it please the Commission, we're resuming with evidence from the Premier. Before the lunch break, Commissioner North put a question to the Premier on notice for her consideration over the lunch break. I might invite the Premier now to respond to Commissioner North's question.
Thank you, Council assisting, and also Commissioner Lovett as well. Would you like me to do those together, or would you follow sequentially? Okay, yeah, thank you. So Commissioner North, you did give us quite a lot to think about over the break, and I think it is a really important question because it goes to the heart of why we are here. It is about we want to get better outcomes. We need to do things differently, and we need to understand how, through this truth-telling process, what has caused this disadvantage and disconnection as a result of the dispossession of land, and also how what has been tried for decades now hasn't worked, and how we need to do better and do differently. And I think in the context of your question around the work of government, and you've mentioned the frameworks, many frameworks, and previous commissioners have mentioned this as well. There have been many, and I feel that speaks to there has been a lot of best endeavours, a lot of good intent, but that in good intent hasn't necessarily been had the right practices of particularly self-determination embedded in them. An area of good practice, or a good example, has been in the area of Aboriginal housing, and where we have seen the transfer of housing and resources to Aboriginal housing Victoria. But I acknowledge that is one example, and we need many more. So in terms of going forward, to answer your question about what's different, particularly to what is going to be different, is that the embedding of the principles of self-determination in our approach, because previously governments, different agencies and different organisations have come to these issues from a deficit perspective, not an empowering perspective, and that is what's fundamentally different about treaty process. But also what is different in terms of our work on treaty is that it's legislated, it's law. It's law that we sit down and negotiate treaty. It's law that we have the independent umpire, the treaty authority, that sits over the work of the parties to the negotiation, and they will be holding the parties accountable. So what is different going forward is that the framework we have in place, the treaty framework, it's enforceable. There's accountability, particularly on government, and that it is a negotiation that is both parties sitting at the table as equal, again with the treaty authority as the independent umpire sitting over the top of the work that they do. And also too, what is very different and very important as part of this is the First Peoples Assembly who come to the negotiating table. They're an elected body in their own right. It was, I think, really a sign of the commitment from First Peoples here in Victoria about their commitment to being involved in the process, that with the second election of the First Peoples Assembly, we saw more First Peoples participate in that election than the first one. So we have an entirely different approach that is driven by those principles of equality, accountability and enforceability, and that they're required of the government by law. So I acknowledge that there is some way to go as we work through treaty negotiations, but I hope that gives you a sense that, pardon me, that the government has recognised that past practice has not worked, that we need to do better, we need to do differently, and that's also been acknowledged through the recent report of the Productivity Commission into the closing the gap measures, where it says very clearly that business as usual has not worked. It is not working. It speaks to the need to do things differently, and it points to the work we're doing here in Victoria. So I appreciate that there is still a journey ahead to get these better outcomes, but in terms of what's being done differently to get there, I hope that answers the question for you in terms of how we're doing things differently. We're determined to do things differently, and we've got legislative requirements to do so.
Before you move on to Commissioner Lovett's question, Premier, I might just test a couple of matters with you.
Yes.
You've said that in the treaty negotiation process that of course nothing is off the table, but one of the or two of the measures that have come up in the evidence as potential ways to ensure that the compliance of the administrative government to these policies and plans is by ensuring that the executive officer or the secretary of each department has a contractual responsibility to deliver on the self-determination outcomes, and that First Peoples are part of the monitoring and evaluation of performance against those contractual provisions, so that if a departmental secretary general is overseeing an agency that's not performing, then they are answerable to the First Peoples who ought to be beneficiaries of that particular strategy or plan or a project. And so I'm expecting that you will say that, of course, that type of outcome is not ruled out. Is there anything that is in place at present that resembles that sort of monitoring and performance measurement in a way that the First Peoples of Victoria get to have a say about that level of government management?
Council assisting is correct. I will remain disciplined and not cut across the treaty negotiations and give a view about what I think should and shouldn't be discussed at that table, other than to note that those recommendations and suggestions are there, and I note and acknowledge them, and that they can be part of that process. In terms of the second part of your question, if I can just clarify, Council assisting, when you refer to the accountabilities of secretaries and senior public servants around their performance, did you also mean, in terms of your question was about First Peoples' involvement in monitoring that? Can I just clarify that was your question?
Yes. So what role does the Assembly or other community organisations or have in the oversight of performance at the present time by those executive level officers?
So to my understanding, I don't believe there is a formal mechanism for First Peoples Assembly to be involved in the monitoring and oversight of department secretaries' performance. That responsibility sits with me as the employer of departmental secretaries, and there are regular performance reviews of secretaries that assess them as to how they are acquitting their responsibilities across a whole range of indicators, but particularly around implementing the government policies and directions of the day. I will reflect on that question and how it intersects with the current arrangements before we get to treaty process, because if you consider the government has a policy framework of embedding self-determination in our work, that may be something I should consider, embedding in secretaries' performance measurements. I'll take that one on notice, Council assisting. I think it is a thoughtful observation that has been made, but in terms of how it intersects, those formal mechanisms intersect with recommendations that may come out of treaty, I will not cut across those negotiations, as I've said previously.
Thank you very much, Premier. If you could now turn your mind to Commissioner Lovett's question.
And Commissioner Lovett's question, your question indeed goes, it is a similar vein to Council assisting's question around how are we going to be ready, how the government and the bureaucracy are going to be ready. There's a lot of thought and work going in by the First Peoples Assembly, and the work that's happening right now in talking to groups across the state, on country, having conversations about how First Peoples can be ready to come to the negotiating table from their perspective, equally too, government has to do its work in being ready to come to the table. And at the conclusion of this conversation, Commissioner Lovett, I'm happy to provide further written advice as to some of the processes, because there's two answers to this. One is a process question, and one is how is government culturally ready to come to the table. In terms of there's processes in place around. We have government endorsed in late last year, in December of last year, the whole of Victorian government treaty negotiation model. And that includes the rules of treaty making that have been agreed between government and the First Peoples Assembly. We have cabinet, committee and interdepartmental structures to support the work of government. And we have put additional resources into every department to help them to be prepared to do their preparations as part of their work to be ready for treaty negotiations. That's the mechanics. But then there's also the cultural requirements on how we are culturally ready. There is, going back to that previous question, there are requirements for secretaries to be responsible for oversighting within each of their departments, not just the process and the mechanics of being ready to come to the treaty negotiation table, but also to bring the policy and the work and the responses for government. But also to Commissioner Lovett, if I could put it this way, I think the treaty process is going to flush out which bits of government are ready and which bits might need some further work and support to be ready to participate in treaty processes. As we've just discussed, there is a lot of good work, a lot of good intent, a lot of best endeavours, and some parts of government have gone a bit further than others. So I think the treaty process is going to be important to help lift all parts of government to be both ready from a process point of view, from a cultural point of view, from a policy point of view. And if I can go back to that the example I used earlier, when you came and presented to Cabinet and led a discussion around understanding what self-determination really meant in action, as I understand it, it came as a consequence of there being a view that it was not as well understood across government as it should have been. And that certainly assisted. That conversation certainly assisted all ministers, and to then go back to their departments to have those conversations. I see Treaty doing something similar on a much broader canvas across government. And then there's, of course, those accountability measures that I spoke of earlier, both legislated accountability measures that will be enforced by the treaty authority, the independent umpire, and then accountability measures that myself and my cabinet colleagues will be driving with their senior department officials, because it's our expectation that this government policy, it's our determination that this government policy be delivered.
Thank you, Commissioners. Premier, with other witnesses, when we've discussed this topic, there have been questions, particularly from Commissioner Hunter, regarding the existence or otherwise of consequences for non-performance. And I'm wondering whether you can identify what consequences there are for government agencies that fail to perform in terms of their self-determination programs.
So outside of the existing consequences, the existing accountability requirements that sit on secretaries and senior department executives, again, there is none that I am aware of that go directly that relate to implementing government policy as it relates to treaty and treaty outcomes. It is something I will reflect on following today's hearings, because I think it does go to, again, the questions from Councillor Sisting around what are the accountability measures and where is the opportunity for First Peoples to have a role in that. So I may take that one on notice and give that some further thought, because again, if we are, as we've discussed, it's about doing things differently and driving change, we need to consider how we hold ourselves accountable as well.
Thank you, Premier. Is there any follow-on from that you wish to make, Commissioner Hunter?
I think there's just something I thought about a bit earlier before we went to the break. And, you know, we talk about these policies and these practices, Yet while we're sitting here, there's a coronial inquest of Heather Calgarrett. She couldn't wait. So she couldn't wait for some of these to change now, these harms that are happening now. Totally get treaty, all of that, and we've spoken about that. But what happens for those harms that are happening right now? What are those mechanisms that are going to stop these things happening now?
Look, I do acknowledge, and Commissioner Hunter as acknowledging, yes, there is a coronial inquiry being held right now in parallel, and that is not lost on me in terms of both the loss associated with that hearing, but also to your observations that action is needed now. And it goes to the discussion we were having earlier that there are actions being taken across government in a range of different areas. And again, I acknowledged earlier that in some of those areas they don't go far enough and they don't go far enough fast enough. I though reaffirm that it is our commitment, my commitment, the government's commitment to change the way we operate as a government when it comes to working with First Peoples on how we make decisions that affect your lives, because we know that's where you get better outcomes, and that's what we're driving to through treaty process.
And that's all good and well, and we know treaty's going to take a while. It's just those harms that are happening now are really important because people are dying and families are being ripped apart. And you know, it's not just felt by one family, it's a ripple effect throughout our community. And I just want government to reflect on that, about what is it? And the Assembly's already there.
Mm.
And some of this stuff can't wait. And maybe that's negotiations with them now around those, I guess, policies or procedures that need to happen urgently.
I do acknowledge that. If I could acknowledge that statement, Commissioner Hunter, and again, reflect on it. There are already, and I know you've heard from other ministers, the Minister for Child Protection, for example, and I know this is an area you've also particularly focused on, where we are, as a result of significant amount of work that was First Peoples led a year or more ago, is bringing about change to that critically important area of supporting and protecting children and families. And there is change coming about in that area. I mentioned the Aboriginal housing example. There is work that is ongoing, and the fact that these hearings are being held in a very public way, in a very importantly truthful way, I know from discussions with officials that this is already requiring a change in thinking about existing practices. So yes, it is correct to say there are two. It is correct to say a lot of I won't cut across what's going to be discussed at the treaty negotiation table, but what we are discussing here today is already having an impact in terms of people who are working with Aboriginal controlled organisations or working with First Peoples families about how we need to continue to be better now.
I'd just highlight what Commissioner Hunter has raised. She's drawn attention to sort of the dramatic cases of where a death is involved. And this is the second thing that I had in mind to raise with you, because it's the other matter that's become so clear in the hearings to me, and that is that the overall life of very many, if not most, Indigenous people is affected by a feeling of exclusion, a feeling of rejection. We've come across it time and time again. Ordinary Indigenous Victorians who just feel, as a background to their whole life, that they're second class, they're not listened to, they're pushed aside. And of course, that's not dramatic. That doesn't get into the coroner's court. But I just wondered whether you accepted that that makes it really important for changes to happen quickly and in many instances prior to treaty negotiations, because I fear that treaty negotiations, they're going to be very complex and they're going to take a long time. But ordinary members of the Indigenous community need some reassurance to feel accepted and feel that things are moving in the right direction. I wonder if you have a reaction to that.
Commissioner, as you were raising your question, I was reflecting on the welcome to country from Andrew Gardner earlier, and how he spoke to those feelings of First Peoples again because of the way the state was settled, colonised, because of that disconnection and dispossession of land. That continues today to result in, and apologies if I'm paraphrasing incorrectly, but the consequence today of marginalisation, of racism, ongoing racism that continues to be experienced, that marginalisation that you spoke of. So whilst you were asking your question, I was reflecting on how today's Welcome to Country was in part framed, was around that ongoing impact on First Peoples in Victoria. And so again, in answering about taking action quickly, that is why there is work continuing across government across a whole range of different portfolio areas, some of which I touched on in response to Commissioner Hunter's question. And these hearings are already bringing about, I think, a change in thinking, preparing the preparation that goes for ministers and departments to come to be ready to be our best before you today has required a huge amount of thinking and has challenged the way we work already. We've had this discussion, we don't talk too much about what happens at the cabinet table, but we've had these discussions in the cabinet acknowledging that we need to be ready for treaty, but we also need to be recognising that we can continue to make change and drive better outcomes along the way.
I'll just ask one more thing. Premier, you said earlier you've been on your own learning journey around uncovering the truths around massacres and even just in Onjara country alone. Do you accept that First Peoples have been advocating and articulating what's happened for, since the whole time, really? So I understand you're on your journey, but our people have been saying this for 200 years, what really happened to us. I just wanted to see if you accept that.
I most certainly do. My references to my learnings speak to, it's not that I, before my appearance today, was not aware of the dispossession and the disadvantage and the wrongs that were occurred at the point that the nation and then the state was colonised. It was my learning was deepened by and expanded in terms of the brutality. That was the thing that was the area that was particularly concerning to me, that I hadn't learnt of that, the depth and the extent of the brutality that went on as part of that. So I most certainly accept that the conversations and the points didn't start with the commencement of this truth-telling commission. There have been First Peoples going back since the very first time, 236 years ago. And I was reflecting when we were at Corranderk last Tuesday that in the face of centuries of dispossession and disadvantage and what that has resulted in, we continue to see the strength and the resilience today of First Peoples culture continued to being practiced, the work that is being done to re-establish that connection with language, with dance, with culture. And I think that, again, that is something that Andrew spoke of earlier as well, that strength and resilience, which is quite remarkable given that experience of colonisation.
Thanks. Just Not only resilience, but resistance.
Yes,
Thanks, Premier.
thanks.
And Premier, I just want to take you to some evidence that was given in Robinvale on the 23rd of April. During that hearing, Minister Harriet Shing, Minister for Water, gave evidence that the total revenue received by the Victorian government from water alone for the 13-year period from 2010 to the financial year 2023 has been just over $83 billion. And it was her evidence that none of that $83 billion had been distributed to First Nations for the purpose of acquiring water, which has been the consistent ask for First Peoples in relation to their water rights for some time. It was then put to her that there is nothing stopping the state of Victoria, responsible as it is for the dispossession of First Nations peoples from their lands and waters, from funding a buyback scheme to enable traditional owners to purchase direct water entitlements beyond political will. Now, that's the evidence given, and in response to that question, Minister Shing said, no, there's not. Do you agree with that observation from Minister Shing?
I would. I've not had the opportunity to review her transcript, but I would acknowledge her presentation of that. I would agree with her presentation of that.
We understand that the term political will has a broad range of meaning, but the question then must be asked: why has there been no political will to fund water buybacks when First Peoples have made it abundantly clear over a very lengthy period how important water is, particularly cultural flows are, to the health of their country and to the health of their communities?
Commissioners, I'm not certain I'm able to give an answer to why historically there has not been the political will to provide the capacity for First Peoples to buy back water. Water is the regulation of water is an incredibly complex area and very contentious and contested area across the community. I'm not in a position to be able to answer why that has not been the case to date.
It is the case that you haven't been in the position of Minister for Water at any time during your parliamentary experience.
We live in the Murray-Darling Basin, though, and are very familiar with the challenges of water. But no, I've never held that portfolio.
But the intent of the question, you would understand, Premier, is to examine why it is when there is so much money washing through, if you'll excuse the analogy, so much money washing through the water sector that none of it has been made available to First Peoples to buy back water, which, you know, they shouldn't arguably have to pay for anyway. But it seems to be the only way into an over-allocated water market.
Yes, I do accept that.
Now, I just want to show you an article from the Australian Financial Review, and it should appear on the screen. You just zoom in on the title. The developers swoop on $200 million of outer Melbourne housing sites. The article is a December 2021 Australian Financial Review article, which shows that $200 million was paid for 85 hectares at Mickleham on Melbourne's outer north. From that, that parcel, or those parcels, there's two parcels involved, it was proposed that there be a housing development, residential housing development, which would clearly was intended to make the developers a significant amounts of money. The purpose of showing you that is not to make any observation about that particular transaction, because there are many like them, as you will be aware. But if we go to the next slide, you will see that the properties, the subject of the transaction, are the ones outlined in yellow on the map on the left, 35, 37, and 38, and
and the yellow to the right is the second small piece. And you can see on the map on the right, it's an old parish map from 1858, which shows the original purchase of that land or acquisition of that land by grant from the Port Phillip Bay governor or the New South Wales governor in 1848, sometime around there. Now you can see, if you look closely, you would see that the land is in the ownership at that time of Archibald McLaughlin and an R. Brodie, and it was known at that stage as a part of the Dunhellen estate. And so the person who was referred to on that document as Archibald McLaughlin was the original grantee of that land, which was, of course, lands that shortly before was in the ownership of First Peoples. You can see that? Now, these lands, it's clear, were taken from their owners and given to British squatters or free settlers in 1848. The point of taking you to this material, Premier, is to simply to illustrate that there is extreme wealth being made from parcels of land that were once owned by First Peoples, for which they've never been compensated. Do you accept that?
Yes, I do.
Never been compensated. The second point is that unless there is substantial investment in a land redress or buyback scheme, First Peoples will never be able to afford to participate in the market nor afford to live on the best lands on their country. They will be relegated to the poorer, cheaper lands because they can't afford to pay the top dollar for the best parts of their land, which they would have enjoyed themselves once upon a time. Do you accept that proposition?
I certainly accept that ongoing economic disadvantage has its origins in the dispossession of land at the point of colonisation.
But do you accept also that the value of land as it now stands and the ongoing increase in the value of land will mean that it's highly unlikely that First Peoples in Victoria will ever re-own the most valuable parts of their country?
It is difficult for me to answer that in a universal way, but most in the. Apologies, Council Commissioners. Let me start that again. It's challenging to answer that in its broader sense, but in terms of the issue of the disconnection of land and its connection to wealth, absolutely agree that it is difficult, very difficult for First Peoples to be able to have land that they never ceded be returned if there were attempts to purchase it on the open market.
It's, Premier, you would accept that it's no coincidence that the lands which were the subject of villages and ceremony and activities, ritual, were also the lands that were in the best locations, closest to water and animals, and they are the very locations that the squatters sought out, and they were the first to be taken, and they are now the most expensive in the state. And is it the case that First Peoples in Victoria have to get used to the concept that they will never get the best of their lands back?
Commissioners, that is challenging to answer because, again, I'm not going to preempt what this Commission may recommend to government or what may be considered as part of treaty negotiation, but I will acknowledge the statement that it is very difficult for First Peoples to, as I said before, purchase land on the open market. That prime land that you spoke to, there's always a very strong connection. Good land is often associated with a good water source, and the value goes together. So I do acknowledge that.
And perhaps going back to the question before, in circumstances where there's no ownership of any water rights either, that issue is then compounded, is it not?
I would agree with that.
And do you accept that
in terms of the ultimate treaty outcomes, that land ownership in freehold might form a significant part of the equation.
I accept that that may form an outcome in the treaty negotiations consistent with my determination not to cut across the treaty negotiations.
And I've tried not to hem you in too much on that one, Premier, but it may. I'll turn now to an associated question. Is the state currently setting aside money now in preparation for treaty settlements to allow the purchase of these very important lands for First Peoples?
That's yeah, I anticipate what that conversation may be. That is very difficult for me to answer, as it cuts across cabinet and budget deliberations that I'm simply not in a position to be able to canvass here today.
Is there an existing bucket of money that exists within Treasury that has already been established for the purchase of lands by First Peoples?
Again, that cuts across cabinet discussions and deliberations, and I'm just not in a position to discuss that today. I will note we have made available funds through the Self-Determination Fund, but beyond that, I'm just not at liberty to discuss government decisions around financial allocations.
I'm not talking about future allocations or the content of the coming budget. I'm talking about what the situation was, say, at 31st of December 2023. Was there a bucket of money in existence that the government had set aside?
Sorry to interrupt my learned friend for a moment.
Mm-hmm. Do you have any knowledge of the existence of such an account?
Well, the way our budgeting works, if once a government, funds are not held into accounts for purposes of portfolio allocation, they come from consolidated revenue. So should government choose to make a decision in the future to establish such a fund, it would come through consolidated revenue. However, I would point to, in terms of this line of questioning, draw attention to the first principles review and the interim community benefits formula that was released last year, early this year, from memory, so I'm just trying to remember the correct date, which does speak to, in terms of supporting land justice and recognition of this area as being an area we need to address, that this is one where to help guide the agreement around, to help guide discussions to land agreements around land use agreements with traditional owner groups across the state.
Thank you, Premier. I appreciate the difficulty in asking the question in the way that it's been put, but I appreciate you giving it an attempt. Could turn to paragraph 176 of your statement, Premier. You could see that on the screen, please, operator. That paragraph reads, I acknowledge that structural racism exists and that the state must work to address this through self-determination. I recognise in this government's commitment to self-determination and treaty that better outcomes are achieved when First Peoples are empowered to take control of their affairs. So you've noted explicitly in that paragraph that there is structural racism present in Victoria, and I'm assuming that the paragraph is specifically directed towards the Victorian government. What measures are your government taking to ensure that the exercise of government power doesn't continue to
harm First Peoples by reason of that structural racism?
In answering this, I may go back over some of the ground I covered with Commissioner Lovett, because it does go to that point around how government is culturally ready to come to treaty negotiations, understanding that the way the state and the institutions have evolved over the passage of time, that there can exist in parts of government. Sorry, I should be clear, can and does exist in parts of government structural racism that can be a barrier to equal participation and good decision making for First Peoples here in Victoria, and that is why the work we are doing to get government ready to come to the negotiation table has to recognise this within our own departmental and organisational structures, how we engage with First Peoples, and that is why the policy foundation of self-determination is so important, because it's not engaging with First Peoples, it's making sure that the framework is a self-determined one. And it is something that we do need to continue to work hard on. I acknowledged earlier this is something that's going to be a challenge for government, but we need to, we need to push on. We need to be better to address some of those areas of government that continue to be a barrier to equal participation.
So when you were talking about structural racism in paragraph 176, when that paragraph was being written, did you have in mind the failures to deliver and the failures to implement that have been taken up so much of the time of this commission?
I had in mind that the structures that we're in areas of government we continue to work in are a barrier to being able to address the areas of systematic and ongoing disadvantage. It is why these the appearances by government at this commission is so very important, because we are deeply challenged by this, and those who work with us are deeply challenged by these conversations. And so it goes to the question, we're not going to wait for treaty to bring about change. We need to bring about change as a consequence of these discussions through the Yoorrook process. But again, it does speak to why treaty is so important, because it's about putting in place a different structure that doesn't have racism, it doesn't have those structural racist elements that it's built on. It is a completely new structure that is accountable, that has accountability mechanisms around it for government, that has an empowerment mechanism where we come to the table as equals, and it's got enforcement through law.
Thank you, Premier. I want to take you now to paragraphs 94 and 95 of your statement. Paragraph 94, you refer to the Privy Council decision in the case of Cooper and Stewart, an 1889 decision. You note that 1889, the government's ownership of Victoria was confirmed by the highest imperial court. The Privy Council determined that the colony of New South Wales consisted of a tract of territory practically unoccupied, without settled inhabitants or settled law at the time when it was peacefully annexed to the British dominions. And you've acknowledged that I believe that decision had numerous factual errors. In paragraph 95,
Yes.
Do you accept that? And so in paragraph 95, you say the statement was taken as establishing that in 1788, New South Wales was uninhabited. This was factually incorrect, but legally the decision had operated to deny recognition of previous Aboriginal custodianship of the lands until the High Court's 1992 decision in Mabo and others versus the state of Queensland, number 2. The factually incorrect elements of that decision, I would suggest to you, include that the holding that there were no settled inhabitants, You're nodding your head, yes?
Yes, I'm agreeing with that, yes.
No settled law, and that the lands were peacefully annexed by the British to the British dominions, and we know full well that it wasn't a matter of peaceful annexation. You accept that?
I do.
Yes. Now, do you agree? This is about. I'm talking now about the decision in Cooper and Stewart. Do you agree that the imposition by the British government of tests, in this case terra nullius, which they've developed under their own legal system to determine who is sufficiently like them to warrant being recognised as capable of having rights, that mechanism for acquiring other people's territory is particularly odious. Would you agree with that?
Yes.
You're not. They were saying you're not sufficiently like us for us to respect your rights.
I find it disgraceful, and I would agree it's offensive.
And I suggest to you that it was a convenient fiction that the British and colonial governments created to avoid having to recognise the rights of Indigenous peoples in the territories it took by force. Do you agree with that?
I would agree with that.
I also suggest that it was never the case that the colonial governments believed that First Peoples had no laws and no territories. It was known from the very outset. Are you sufficiently familiar with the early history to accept that proposition?
Yes.
Yes. So we've already established that you're not a historian by trade or training, and not a constitutional lawyer. I just want to take you through a number of documents which might form part of the historical landscape that exists as a sample of the many documents in existence having bearing on the formation of the colony and the alienation of First Peoples lands. The first document I want to take you to, though, it serves two purposes. It serves a purpose in terms of understanding the view of the Secretary of State for War and the Colonies, as he then was in 1840, Lord Russell. It serves the purpose of demonstrating his attitude then, but it also raises another more contemporary question. This dispatch from Lord Russell to Governor Gipps on the 25th of August 1840, tab 9, document number 9.
Don't have tab 9. I've got it here on the board. Okay.
Can you read that? It's very difficult to read, I accept.
Thank you.
It's part of a longer dispatch, and at point 6 it says, I have not yet touched on the application of the land fund to the protection of the Aborigines. It is my opinion that 15% of the yearly produce of sales should be so applied. So in 1840, the Secretary of State for War and the Colonies is telling the governor of the New South Wales colony, Victoria hadn't then split off in 1840, he's telling the governor of New South Wales that he needs to put aside 15% of the yearly produce from the sale of lands. So that speaks to, for the benefit of First Peoples. That speaks to, I suggest, an understanding that the lands were the lands of the First Peoples, and secondly, an obligation to ensure the protection and benefit of First Peoples from that the effects of what was known to be occurring in the colony at that time. I don't intend to ask you to interpret these documents, Premier, but I will raise a number of them and just
make certain points. With respect to this document, however, we just need to make clear that the Victorian government doesn't presently hold an account which has set aside 15% of land sales since 1840, does it?
That is not a current policy position of this government, although I will draw attention to the pathway we have laid out on reaching future land use agreements with traditional owner groups.
And you're not aware of there ever having been a land fund set aside for our Aboriginal people in which 15% of land sales are accumulated?
No, that's not to my knowledge, no.
We could go to the next slide. Can you see that?
I can. Thank you.
This is an extract of correspondence from Governor Phillip to Lord Sydney in the 16th of May 1788. So Governor Phillip had been in charge of the penal colony at Port Jackson for a mere 3 months at that stage. And he makes the observation, the not having the power of immediately granting lands to the officers likewise feels as a hardship. They say they shall be obliged to make up their minds as to whether staying in country or returning before they can know what the bounty of the government intends them. And the point of bringing this to your attention is simply that there's an expression by Governor Phillip of the limits of his authority to grant lands. The next document, if we could turn, please. Is another dispatch from Governor Phillips to Lord Sydney. Yes. And this one is dated the 9th of July, 1788. The point of this particular extract is simply to note that even this is in July 1788, some 5 months after establishment of the penal colony at Port Jackson, Governor Phillips says, nor do I doubt but that this country will prove the most valuable acquisition Great Britain ever made. So it's clearly on the mind of the governor that they're onto something big here. And he's communicating that back to Lord Sydney, the Secretary for the Colonies. If we could move to the next slide, please, which is document 10 in the bundle. Yes, please. Sorry.
Oh, thank you.
Now, this advice, or this extract of advice, is an advice from Mr. W. Burge, an opinion, which was signed by two other prominent lawyers named Pemberton and Follett, and it was executed by Burge on the 16th of January, 1836. So this is some...
Could I just get confirmation of which tab I'm up to?
Sorry?
Did you say this was under
10,
tab 10?
I believe. 10.
Appears to be the document.
12, perhaps. 12. Sorry,
Okay.
Premier.
Thank you.
No, I can follow now. I can follow now. Sorry, my error. A bit of user error, commissioners.
It's a problem.
Take responsibility. Now you can see that document, Premier.
Yes.
It's an advice prepared for the Port Phillip Association about the legitimacy of Batman's Treaty. Okay, the people that prepared the advice were Burge,
and it was also signed off by Pemberton and Follett. Yes, it's got. If you turn to page 324, Premier. If you're having difficulty reading on the screen. And so they were asked to advise about to advise the Port Phillip Association in effect about the Batman Treaty and grants in accordance with that treaty. They say, I'm of the opinion that as against the Crown, the grants obtained by the Association are not valid, and that as between Great Britain and her own subjects, as well as the subjects of the foreign state, the right to the soil is vested in the Crown. It has been a principle adopted by Great Britain as well as by the European states in relation to their settlements on the continent of America, that the title which discovery confers on the government, by whose authority or whose subjects the discovery was made, was that of the ultimate dominion and sovereignty over the soil, even while it continues in the possession of the Aborigines. The principle was reconciled with humanity and justice towards the Aborigines, because the Dominion was qualified by allowing them to retain not only the rights of occupancy, but also the restricted power of alienating those parts of the territory which they occupied. Now, the important part of that particular advice is that even under a view of the world that provides that the British could acquire dominion over lands occupied by other people, the First Peoples of that country continue to have rights against the rest of the world in terms of occupancy and the use of their territories. So that's the importance of that advice. So this was in January 1836. If we can just turn to the next document, which is document 13 in your bundle. And I hope you've got the extract. It's a huge document, and we're looking at page 389 and 390 of the next document, which is, I think, 13 in your bundle.
Yep, thank you.
This advice is similar to the Port Phillip Association, and it was given on about the 18th of January, but it's noted here April 1836, which is the date at which the advice of Lushington was sent to others to review, and ended up in this historical note. The advice was given a matter of days after Berg's advice, and it seems that the Port Phillip Association may have been shopping for opinions, as people want to do. What Lushington said, and it should be observed, Dr. Lushington was a parliamentarian at this time, a judge in one of the courts in England. You could do both in those days. I'm sure there'll be many politicians who'd like to do both today, but
I'm happy to leave the judiciary to the judiciary assisting.
He says, in his opinion, I'm of the opinion that the grants obtained by the association are not valid without the consent of the Crown. And then in 2 and 3, I do not think that the right to this territory is at present vested in the Crown. So this is 1836. This is advice from England, saying on the record, it forms part of the historical records of Australia. Lushington is saying, I do not think that the right to this territory is at present vested in the Crown, but I'm of the opinion that the Crown might oust the association. I then ask you to turn to the next document, which is document number 14, which is another extract of a dispatch from Governor Burke to Lord Glenelg later that same year, on the date of the 13th of April 1836, dispatch number 45. Yes. Yes. So that's it there. So And if you can see in the margin, there's a reference, decision in Tasmania re validity of titles to land. You see that? And so this is Governor Burke, the same Governor Burke who issued the Burke Proclamation in 1835 to Lord Glenelg, the Secretary of State for War and the Colonies, in 1836, less than 12 months after the Burke Proclamation. He says that by a recent judgment of the Supreme Court of Van Diemen's Land, considerable doubt has been thrown upon the validity of titles to landed property in either colony. So I can tell you that either colony is Van Diemen's Land or New South Wales. It having been decided by the court that His Majesty cannot, without the concurrence of Parliament, delegate a power to alienate the Crown lands. And that the governors of the colonies have consequently never possessed legal authority to execute grants, whether under the old tenure of quit rent or under the present regulations for the sale of Crown lands. So Governor Burke was on notice that there were grave doubts about the legitimacy of what was going on, about the issuing of these grants. And part of the reason it may be, and these will be matters for the commissioners to consider in writing their report and looking at all the material, but part of the reason may be that because the grants dealt with the private property of individuals, namely First Peoples, the royal prerogative was simply not enough. It had to be accompanied by an act of Parliament. And that goes back to the old imperial law. Complex matters, but matters that this commission must deal with. You accept that the commission must deal with them?
Oh, most certainly.
So if we turn to the next slide, which is number 15. The document is lengthy, but you should be looking at page 4. Look at page 4, Premier. So this document is a report from the Select Committee on Aborigines British Settlements, which includes minutes of evidence and sessional papers from 1837. So this is a select committee created by the Imperial Parliament because it was so concerned about the way in which First Peoples were being treated in all of its colonies that it decided to have a Royal Commission and a Commission of Inquiry and determine what was happening. And in that report, at page 4, it says, it might be presumed that the native inhabitants of any land have an incontrovertible right to their own soil. A plain and sacred right, however, which seems not to have been understood. Europeans have entered their borders uninvited, and when there have not only acted as if they were the undoubted lords of the soil, but have punished the natives as aggressors if they have evinced a disposition to live in their own country. If they have been found upon their own property, they have been treated as thieves and robbers. They are driven back into the interior as if they were dogs or kangaroos. So the upshot of all of this is that in 1835 and the years following, when the lands of the First Peoples of Victoria were being handed out by grant or for in respect of pastoral leases or squatters' leases, and people were being driven off their lands and killed, it was known that they had problems with their land system. That's what this document says, I suggest to you. So I don't expect you to answer that. But what the upshot of this is, Premier, is that it is far from clear
that the state of Victoria has had at that stage legitimacy to dispose of First Peoples lands. Then, Premier, I ask you to turn to document number 16. Document number 16 is an extract from a legal website called Osley in relation to a decision of a single judge of the Supreme Court in 1841, so 4 years after the Select Committee. And that case is called R v Bonjon, and it's a case relating to the alleged murder by one Aboriginal man in respect of another. The judge in this case, Justice Willis, he takes on a number of questions which are very pertinent to the matters before this commission. In the middle of the paragraph, you will see in bold, I hope, the words. You won't be able to see it you can see it on the screen. Much will depend on the manner in which this colony is considered to have been acquired. So he's saying that the question of whether this person can be tried under English law, even though he's an Aboriginal person or first person, it depends on the way in which the colony has been acquired and whether the colonial laws apply to this person. He then goes to say repeat the argument of what appears to be the prosecution, and he says that Mr. Clark, in his summary of the colonial law and stated at the bar by Mr. Barry, says that that colonial possessions are acquired by conquest, by cession under treaty, or by occupancy. By occupancy, where an uninhabited country is discovered by British subjects, and it is upon such discovery adopted or recognised by the British Crown as part of its possessions. In case a colony be acquired by occupancy, he adds, that the law of England then in being is immediately and ipso facto in force in the new colony. He further states New South Wales and Van Diemen's lands were acquired by discovery or simple occupation. He then goes on to say, Justice Willis, New South Wales was not, however, unoccupied. As we have seen at the time, it was taken possession of by the colonists, for a body of Aborigines appeared on the shore armed with spears, which they threw down as soon as they found the strangers had no hostile intention. This being the case, it does not appear that there was any conquest, and it is admitted here that there has hitherto been no cession under treaty. So what the conclusion he comes to is that he doesn't have any authority to deal with this person because there hasn't been a lawful acquisition of the property, because there's no... Sorry. The conclusion that can be drawn from following that line of thought is that there are that the mechanisms for obtaining acquisition of lands is by conquest, cession, or occupation. He goes on to say, if we can just go to the next slide. I repeat that I'm not aware of any express enactment or treaty subjecting Aborigines of this colony to the English colonial law, and I have shown that Aborigines cannot be considered as foreigners in a kingdom which is their own. So that's recounted in the judgment of Willis. If we can then just move on for a short moment to slide 11, which is on the is document number 19.
And this will be short. In 1974, A. Woodward delivered an Aboriginal Land Rights Commission report to the Federal Parliament. The second report, dated April 1974, has been extracted here. So the report process came up in the wake of a Northern Territory land rights decision, the Gove case. It was a supplementary document. Okay. The extract that is you've been taken to, Premier, is headed main principles, and unfortunately that's been excluded from the extract. But the main principles, as observed by Commissioner Woodward, were that at the beginning of the year 1788, the whole of Australia was occupied by Aboriginal people of this country. It was divided between groups in a way which was understood and respected by all. At 42, over the last 186 years, white settlers and their descendants have gradually taken over the occupation of most of the fertile or otherwise useful parts of the country. In doing so, they have shown scant regard for any rights in the land, legal or moral, of the Aboriginal people. And it goes on. But at 44, these are simple historical facts which provide the background for the government's expressed intention to recognise Aboriginal land rights in the most appropriate way possible. So even in 1974, prior to the Mabo decision, it was recognised by lawyers, at least, that there were legal or moral rights in the land possessed by Aboriginal people or First Peoples. So the point of taking you through all of those documents, Premier, is to demonstrate, at the very least, there were various differing opinions about the legitimacy of the British acquisition of territory and the legitimacy of its land dealings. Now, you would agree, I hope, that this commission, in seeking to fulfil its terms of reference, must address and make findings about these matters of historical, where there is some historical certainty.
In answering this, I do want to respect the remit of the Commission. Again, won't cut across what the Commissioners themselves may choose to provide findings or recommendations on following the conclusion of the hearings. I will agree that the documents that you have taken us through this afternoon clearly do point to what in my view is the irrefutable point that sovereignty has never been ceded, and that your presentation has demonstrated that the British government of the time was questioning very, very, very much what was going on in the colonies of the time, and that they were questioning these issues as well, like we continue today.
But these matters are all covered by the terms of reference that I took to you to earlier. There's no question about that.
No, there's no question. Your question was started, and maybe I misheard it. I didn't feel I wanted to cut into the role of what the commissioners may recommend.
And I did indeed say that the commissioners must address this, and I appreciate your reservation there, but you wouldn't disagree with the proposition that the basis for the assertion of legitimate authority for the state of Victoria is a proper matter for consideration by this commission under the terms of reference.
Again, the matters for consideration by the commission are, in my view, a matter for the commissioners themselves, and the documentation does again, for me, confirm that fact that sovereignty was never ceded. It was clearly acquired, and that acquisition was questioned, I think, as you pointed out, as far back as 1788.
Now, Premier, this commission has also received evidence from eminent historians that that deal with some of these issues, and indeed, Professor Henry Reynolds, the very eminent Australian historian, referred to the failure to deal properly with the rights of First Peoples as the original sin. Now, bearing that in mind, in evidence to this commission on Friday, the 26th of April 2024, Professor John Burrows suggested that that in resolution of these matters of the historical legitimacy, states such as the province of Victoria or the Canadian provinces or the nation states ought to understand the entry into a treaty by First Peoples as a gift to the state rather than the state giving something away to First Peoples, because it is taking away the uncertainty that continues to exist. What do you say in relation to that proposition?
I have not had the opportunity to review John Burrows' evidence to this hearing, so I feel a little challenged in being able to respond to his presentation of the matters. But it does go to the heart of what we are endeavouring to address through. Again, so I will speak from the point of the government side of the negotiations, what we are endeavouring to address through treaty, which is to address the fact that sovereignty was never ceded, that dispossession, that land dispossession has contributed to ongoing injustice, and how the pathway of treaty will address that and make change into the future.
I don't ask you to make comment upon the legal conclusions that might be drawn from those things, but it is the case, isn't it, that the state of Victoria has never asserted that it conquered the First Peoples of Victoria, that it's arrived at its position by way of conquest?
I think this is indeed a challenging, very challenging area. And in terms of how sovereignty, in saying sovereignty is not been ceded, I do not. I think there is, as we go forward to today, and as we look at how we address that historic wrong in the way the land was settled and address the pathway to treaty, from my perspective, there is an acknowledgement that the authority of the state today is derived from our system of parliamentary democracy. How that has come to be has evolved clearly over that period of time. And it is in that context that I appear before you here today with the, if you like, the authority that is provided through our parliamentary system and through our democratic structures.
It's not the case that when you're appointed as Premier, they give you a box of documents to tell you how the government holds its authority?
There are legal forms and processes by which we are sworn in as ministers, and that authority is derived through the Parliament and our parliamentary structures that is vested in us by the Victorian people.
I don't need you to comment on that, Premier. Now, I note that we are very close to time. Perhaps I will deal with the remaining time in this way, Premier. As has been noted many times during your evidence and in introductions today, this is the first truth-telling commission of its kind in the country. Other states are following, with plans in Queensland. The Queensland Commission is being appointed last week. Tasmania, South Australia, and New South Wales having advertised its commissioners' positions last week as well. As Premier of this state, what legacy do you want to leave as part of your work that other states and territories can learn from?
Council assisting, it is often a fraught path for current politicians and leaders to start to speculate on their legacy whilst they are still in their role. So if you forgive me for answering it, not so much about my legacy, but the legacy for all of us who are involved in this process, because it is, I think if I was to speak of it in terms of being about me, it would be the wrong way to answer that question with respect, because this is a process and a journey that is not about one particular individual. It's about addressing the historic wrong of the way land was not ceded, that how that dispossession has carried through to the present day and caused so much disadvantage, disenfranchisement, economic disadvantage, all the areas that we've been canvassing in terms of how that, as I think you described it from earlier evidence, from that original sin is having its impact on today. And so my determination in terms of the part that I will play in this process is that we achieve treaty outcome here in Victoria. The time that will be in terms of when that will happen, as I said earlier, that is for our treaty negotiators to come together and determine that. But I want what I see as the legacy of this part of the process is to be the writing of the fundamental truth of our history of our state, for that truth to be told in classrooms across the state, understood in organisations across the state, for it to continue to be talked about, because in shining the light on how our state was settled, we can genuinely start to work towards better outcomes, and that is part of the pathway to treaty.
Thank you, Premier. There was certainly no intention to put a jinx on you. Or
I'm grateful for that.
Premier, before, the final question I have is that you made the point of mentioning in your statement the importance of honestly reckoning with our past, and you just made it again. But you made that point in the context of hoping that we can reach for a better future. You've also highlighted the concerns about, I think, about your children, as has Commissioner Lovett, and what they will inherit, and the fact that your children have had the opportunity to learn more about the past than you did. Is there? I would invite you to hazard a guess or tell the Commission what it is your hope that your children and grandchildren might say about this work when this becomes part of our collective history.
Your question was framed as what I hope. So in terms of starting my answer with my hope and aspiration is that they look back and see that we achieved it in the time that we all have in our current roles, that it's not many, many years away. Again, I'm reluctant to put a timeline on it, but I would like treaty to be achieved in as short a time frame as possible. What that time frame looks like will be determined by those around the negotiation table. But I also hope that our children and grandchildren see that treaty was achieved, not just that treaty was achieved, but that as we go together on that journey and on that pathway, that we together linked arms and pushed back against forces who don't want treaty to be achieved in this state, that there continues to be forces that don't want this process to succeed in a treaty outcome, and that we have to be resolute to see this journey through, and that will be challenging for those of us in any aspects of life. That will involve challenging conversations, that will involve difficult discussions, but I personally am ready for those discussions, and I hope that our children and grandchildren see that we were together, be able to work through this point in time and come out the other side with treaty, and most importantly, that when we have treaty, that it gets the better outcomes that we so desire, that comes about of listening and working together.
Thank you, Premier. Chair, that concludes our questions of the Premier. There is time, I understand, though, for any further questions that the commissioners may have, and we extend our gratitude to the Premier for sitting later than was anticipated, but there is still some time, I understand.
Premier, we have in the hearing room today 2 elders that have participated in Yoorrook's processes, Uncle Robbie Thorpe and Uncle Brendan Kennedy. Is there anything you'd like to say to them and to the many hundreds of First Peoples who have contributed to this land injustice inquiry, who are anxious to see timely and meaningful change and self-determination?
Well, firstly, I'd like to say thank you, because I do acknowledge that as uncomfortable and at times challenging the truth-telling is for me and those of us who represent government, it is so much harder for First Peoples, because it is First Peoples' lived experience. It is First Peoples' dispossession. It is something, it is that, and the pain of that carries through to today. So firstly, I want to say thank you to all the First Peoples who have participated either here in this room or in the hearings you've held on country, or in the discussions that have contributed to us being here today. And then the second observation I'd like to make is that in having the strength and the courage to be part of this process, it in turn places that ongoing responsibility on me and on government to achieve the treaty outcome that we are all working towards. And that is a responsibility that sits with me and sits with government, and that continues to drive our determination to deliver the treaty outcomes we are working towards.
One more, and you touched upon this, but I'll just give it further opportunity to elaborate. I've been in every corner of this state hearing my community's truths. They are often raw and hard-hitting, and they probably make government uncomfortable in how they want to see the wrongs righted. But alongside this, I continually hear my people wanting to extend the olive branch, wanting to share our phenomenal culture with the broader community. I don't hear division. I hear healing. And to quote the Assembly, a desire to walk together. I posit the idea of my people thriving and being celebrated as a vibrant part of our community. Being divisive is post-truth nonsense. Premier, I won't ask you to respond to the nonsense, but can I ask you to respond to the idea that truth and treaty processes will bring us all together?
Yes, thank you. And if I could answer this, Commissioner Lovett, by way of telling a story, sharing my experience from being at Corranderk last week, listening to women leaders and future leaders talk about how there has the bringing back, and forgive me, Commissioner Hunter, if I haven't described this accurately, the women's coming of age celebrations, bringing back those cultural ceremonies and what they mean, both in terms of bringing future leaders forward in community, but also to showcasing that, sharing that ceremonies, sharing that culture with the entire community doesn't just bring a generosity of spirit that your comments speak to. It speaks to a desire to walk forward together, to share culture together, to learn together and get a better, stronger community and outcome for all of us. And I was particularly taken by the discussions we had at Corndurk last week about the huge amount of work that has gone into bringing back language, bringing back. Sorry, when I say bringing back, I mean bringing back from decades of language not being spoken to now bringing and speaking it again, to sharing that with community. That for me speaks to what is going to be an incredibly important outcome for Truth and Treaty, is that we can share in this celebration of culture, celebration of First Peoples culture. And that is something that I'm particularly energised by, the opportunity to broaden that those experiences for more Victorians. I felt deeply privileged to have that experience last week, and I would love my kids and lots of other children and families to be able to be part of those conversations.
Commissioner Lovett and Commissioner North and Commissioners. My name's Lyndon, I'm a retired barrister, but I'm here with Mr. Robbie Thorpe, who you've mentioned in your kind words. We have two questions we would like to put to the Premier from the grassroots. I mean, everybody else is paid to be here. There's lawyers galore. Mr. Thorpe is not paid by anyone. He's basically on the dole in a council flat. His people were once the wealthiest people in the state, and they're now the poorest. And we'd seek leave to ask two questions to the Premier while the Premier is here. Mr. Thorpe, as you know, has legal proceedings in the Supreme Court in relation to charging King Charles with genocide, and he's seeking to issue a writ against the state of Victoria. And there may be questions for the Supreme Court to appear here and to explain about the injustice, their part in the injustice against Indigenous people. But with the leave of the Commission, could we take 2 minutes to ask the Premier two questions?
Commissioners,
I can foreshadow what the questions would be, if that would help you make up your mind.
Commission, if I might, thank
I
you.
haven't finished yet. The two questions I would seek to ask are...
If you could just be quiet for a moment. You don't have leave to appear. Commissioners, there is a process set out in the practice direction for people wishing to address the Commission. A method of dealing with this is for the questions to be provided to me, and either I can ask them, or if in my view that they're inappropriate or irrelevant to the proceedings, then I would oppose the grant of leave.
Mr. McAvoy, would a convenient course be to adjourn shortly for you to confer with the people that want to ask questions and take it forward after you've heard what they say?
I would be happy to do that, subject to the Premier's time.
I'll stay here. I don't need to.
Okay. Yeah, we'll have a break.
Thank you. Given that there's been an indication that there is only two questions, I don't expect it should take long, and 5 minutes at the most.
Just stay in the room.
Yeah.
I'm happy to stay in the room if that's helpful.
Um,
Sorry, Council,
um,
please.
Thank you, Chair, for that short adjournment. There are, as you're aware, practice directions dealing with circumstances where additional parties wish to ask questions of witnesses to engage in cross-examination, and that leave of the Commission is required. Normally, 3 days' notice is required. There has been some notice of these questions by email last night to members of the legal team. In the circumstances, Chair, I'm inclined to not oppose the grant of leave for the two questions to be put to the witness on the basis that they're put by me rather than by Mr. Linden or Mr. Thorpe, as is the usual course in accordance with the practice direction that counsel assisting asks the questions. And so I don't oppose the application for leave to ask these additional questions in cross-examination. The questions have been provided to my learned friend for the state, Ms. Bennett. I'm not aware of whether she has any objection to the questions being put, and she might indicate now her position.
So, sorry, Commissioners, we didn't get notice last night, and I'm not critical of that. Just it's difficult to see how this witness can answer these questions because of their nature, but I don't seek to stand in the way of any inquiry that counsel assisting thinks proper or this Commissioner might want to hear. So my job is not to get in the way of anyone asking questions of the Premier. And so I'm not inclined to object, save to note that it doesn't seem clear to me that these are questions which could usefully assist. They seem to relate to matters that are the subject of ongoing legal proceedings, and I'm conscious of the risk that presents the administration of justice more generally. But in the circumstances and given the overriding intention of the state to be as facilitative as it can, I'm inclined to not object, but to observe that these are not matters upon which I suspect this witness could give admissible evidence. But if the Commissioners are minded to hear from the Premier on these questions, I won't obstruct it.
Chair, I note Ms. Bennett's comments and would simply observe that it's not the case that the questions are not relevant to matters before are relevant, in not perhaps in an entirely a manner that that is appropriate for ventilation in this way, but the secondary question as to whether this witness can properly give any admissible evidence is, in response to these questions, is a matter that you're entitled to take into account in terms of the exercise of discretion. If Chair, if you're comfortable to allow the questions to proceed by way of questioning from me, I will proceed with that. Otherwise, if leave's not granted, that concludes the proceedings for the day.
I didn't think we actually agreed to go ahead with the questions in the room. So are you asking another question now? But you
all I'm seeking is advice from the Commission as to whether leave is to be granted to allow me to ask these questions.
You have leave.
Thank you, Chair. Premier, there are two questions. I'll read each of them to you and give you an opportunity to answer. The first question is, Do you accept that you cannot get title to land or sovereignty through acts of genocide and invasion?
Commissioners, I don't believe I'm in a position to be able to answer that question at this stage.
Thank you, Premier. The second question is, given that you accept that sovereignty has never been ceded, does that not mean, without a treaty, currently all land in Victoria belongs to Aboriginal people, and the only law that governs any resident in Victoria is Aboriginal law? In other words, your law is no longer in force and you need a treaty to legitimise your occupation.
Again, pardon me, again, Commissioners, that's challenging to answer. I would just perhaps draw attention to earlier evidence that I provided to the Commission around the state's authority being derived and reaffirmed through our parliamentary democracy and through the people of Victoria.
Thank you, Premier. Chair, I don't propose any follow-up questions from those answers, and I think that concludes the proceedings for today. As my learned friend, Ms. Bennett, is indicating that there's nothing further from her either. I think that it's appropriate that we now release the Premier as witness and adjourn to Wednesday. Tomorrow's a non-sitting day. Adjourn to Wednesday, at which time we will hear evidence from a panel comprising various churches.
Thank you, Council. We have now concluded today's evidence. Thank you. Thank you, Premier. Thank you very much for your staying for the extra time as well.